नले व्यवहार केमती होछि सब डाटा काढी बहुत शिक्षार अछि मो फेवरेट को मु खाऊ लॉलीपॉप मोर ना को तारा आ सप्ताह तारा चोपा छाड़ियो
ସେଟା ମୁଁ ପୂର୍ବ ସପ୍ତାହରେ ଶୁଣୁଛି।
मैं पूर्व सप्ताह ये सप्ताहटा ये कराला पॉज कराला
ମତେ କହିଥିଲା କି 20 ତାରିଖ ପରେ ଟିକେ ମ୍ୟାଟର ଗୁଡା କମିବ।
कमिबनी
ମତେ ଖୁସି
मैटर कमिबो जे तार चोपा छाड़ियो घर को शीघ्र जाय छलो जल्दी साथ हो
ବେଲ ଗୁଡା ସରିଯିବ ଆଉ।
नहीं बेर पे हम काम अछि
That's correct. I don't dispute about that. My predicament is that, my lord, since the Department of Revenue has launched this prosecution, it is like a stigma on me. So, unless that
you call him at 3 o'clock,
Okay.
2 p.m.
Yes.
Maybe
My lord,
pardon,
item
I had
146, my
moved,
lord.
was tagged
1
off
minute.
it was tagged off with another matter, and I had not been heard. But I am submitting a note of submissions, and your lordship may to get it for
Which
2
one?
minutes.
Judgment is
It
reserved.
is a labor matter. Hon'Ble Kumar. It was connected with another matter of Mr. Sahu. I had moved. I was not heard. But it has been reserved for judgment as I found from the. It may be to be mentioned minutes. It will not take 2 minutes. I have given a note.
Okay, bring it in to be mentioned. Tomorrow.
Obliged.
My lord, my pardon.
What do you want?
Theodore is continuing for that reason.
Sorry?
Actually, Theodore is continuing.
I
For
have
that
asked them that the next week all the matters will be listed where the stay is operating.
My lord, it is urgent matter, my lord.
Next week.
Next week. Any date.
Take this also, whether it is included.
Started to make mention, my lord, on bail matter, my lord, urgent matter, my lord, seriously already jumped, my lord, but this.
Bail matter, no mention. It will come automatically. Yes.
My lord, item number 37, 36 from the today.
Yes.
Permitted to withdraw, your lord. I already filed the memo.
Yes, 36.
My lords, may I mention, lords?
Item number 73, my lord.
1 minute. Let's.
Item number
physical
70.
mentioning be over.
Item number 73. I can't be not pressed.
Not pressed.
My lord.
73 not pressed.
Maybe. Pardon, my lord. 75, my lord. I have already filed a memo for withdrawal. Withdrawal, withdrawal.
75.
5.
75. Yes. Any mentioning online?
My lords, may I
My
mention,
lord,
lords?
CRLMC 3208 of 23, my lord. The matter was listed on 13/9, my lord. I appeared on 12/9, but my appearance has not been in the list for which I could not able to appear. And your lordship has reserved the order. Kindly taken up in the to be mentioned matter.
Once you reserved, why should I take it up? You
But
give-
I should have given an opportunity to hearing.
you-
I have
okay,
already
you
appeared on 12, my
you
lord.
file written submission. I can't hear it again. Once again.
May pardon, my
My
lord.
lord,
You file
another
written
item,
submission. I'll take care of that.
item 146, my lord. On the day before yesterday, I mentioned before your lordship that your lordship says that it will be taken up tomorrow. But today I found that it has been adjourned to 29th October, my lord. And kindly be taken up tomorrow, my lord.
No, tomorrow is not possible.
But
May
the
pardon, my lord.
advocate, your lordship already had the
Mail
matter.
matters are there,
Only
how can I hear it?
your lordship already had the matter, my lord. Only they have to examine whether it is a
Take
already I
number-
mentioned day for yesterday, my lord.
My lords,
Item
may I mention?
146.
Yes,
146, my lord.
My lord, I may pardon, my lord, item CRMC 1580/2021, my lord. It is CRPF officer, my lord. He was not present in his village, but his family member
What do you want?
may be listed, my lord. He is falsely implicated.
No, it will be listed. It
It is
is
of-
coming on the,
it is of
in
to-
a serious time it comes.
My lord, it is of 2021 year, my lord.
21
21 saal.
Even matter, all the matters will be listed.
And
My
another
lords, may I mention?
15, my
Lords,
lord.
may I mention?
15.
15, my lord. 15.
What do you want?
Maybe listed, my lord.
Which year?
15, 15.
2015.
Yes, my lord. 21 is 21, another is 15, my lord, old man.
Thank
My
you.
lords, may I mention?
Yes,
My lords, it's a 2011 appeal, my lords, 308 of 2011 lordships had asked us to start, we had started, but the matter is no more being listed. My lords, may I kindly keep it on 24th lordships?
is it there in the list?
Not in the list, my lords. It was in the list, then subsequently brought to supplementary list, but now it's not reflecting the list, lordships.
Which this?
A criminal appeal 308 of 2011 lordships.
308. Include. Okay.
My lords, 24th, if possible,
Okay.
lordships. Physically, lordships, I'll come and argue the
You
matter.
come over. See, after 3 o'clock, if I get time, I am hearing appeals.
Please,
also.
lords,
You should be
I'll
ready
take
on
my
that
chance,
day.
lords.
You come
Please, lords.
24.
Please, lordships.
Include it. Yes.
Item 1.
Yes. Yes, sir.
On the ground of compromise method.
That gunshot injury grievous in nature.
Huh?
Gunshot injury.
Oh, yeah, I told you to get some judgment.
Yes, honorable Panjama.
Have you seen it?
No.
Eh?
Not exact decision, my lord. What happened, my lord? This petitioner, my lord, so far the Panjama decision is concerned, my lord. This petitioner is concerned, he has not fired. He is juvenile, my lord. He is only Lalkara. That is Paragraph 2, my lord. Petitioner was found to be juvenile during course of investigation, and it was also found that co-accused Russell Singh hired at the husband of the complainant only a Lalkara was attributed to the petitioner.
Lalkara.
And Kwa, the case Kwa,
Lalkara accused can be.
but
Get some judgment. Why you
It's a fire gunshot matter.
fire means
Gunshot.
see who is this is Yaswant Singh.
Matter.
Yaswant Singh is the Lalkara accused.
Yaswant Singh Lalkara. That is the
Who has given the fire? This
fire Russell Singh fire and the husband of the complainant.
Russell Singh's case is
Second.
not first.
First paragraph, second paragraph.
That's the problem. You
And but this in this judgment, my lord, though the Honorable Court Punjab and Haryana, my lord, relied the Gyan Singh and also the Narendra case, my lord, but in fact
Finally.
was the case so far the petitioner is concerned. Wow.
because he has limited role, na?
Unlimited role and also juvenile.
Juvenile.
And they also, my lord, cited another judgment, my lord. The petitioners, my lord.
Narendra Singh.
My lord. In that case, my lord, though the injury grievous in nature, but assaulted by means of knife. Not hand.
Knife and all also,
Fire.
right. Arms act is there and fire.
I read out, my lord, in that case, my lord, one paragraph only, my lord.
Yes.
Better appreciation, my lord. Narendra Singh, my lord. Paragraph, my lord, they have certain guidelines, my lord. 6 guidelines. Offense under 307 Indian Penal Code would fall in the category of the heinous and a serious offense, and therefore is to be generally treated as a crime against the society and not against the individual alone. However, the High Court would not rest its decision merely because there is a mention of Section 307 Indian Penal Code in the FIR and a charge is framed under the provision. It would be open to the High Court to examine as to whether incorporation of Section 307 Indian Penal Code is there for a sake of it, or the prosecution has collected sufficient evidence, which is
again on merit.
Merit, my lord.
307 is made out or not.
For the purpose of it will open to the High Court to go by the nature of an injury sustained, specifically whether the injury is implicated on the vital, delegated part of the body.
Here,
It's a belly, man.
Belly. Vital.
And in the judgment, kindly para 35
Only
dollars.
because
In the para 35. However, a present statement absence record.
I remember this judgment. You will get the judgments installmentally. Get some other judgment which you must read it. This is not helping you.
This is what I've found it only for.
You are not researching. Shall I do for you?
Right.
I'll reserve the judgment. I'll do it myself. Okay.
No, my lord, I will another judgment.
What is this?
Another judgment.
You took
After vacation, maybe.
2 years, 2 weeks for research. Not able to get you are getting a judgment which goes against you. after November रख दिया चलो
After Puja vacation,
request yes yes next
Item 2.
Petitioner challenging the order of cognizance,
yes
brother-in-law and sister-in-law of the informants, all along residing at Bangalore, the service place, having no contribution under 498, the general in nature. I want to was taking against
Samir Das and Suman Manti yeah
mine.
yes
All along I have attached all the documents, and she had admitted in 161 that she had been 4 days to Bangalore to remain in the
just see
Last of the lordship directed him to implement the complaint as a.
Yes, I have filed it today. I think for
today
I have filed.
Sir, to go, my lord.
Let it-
I is allowed implement
I may
opposite
permit
party,
it here.
informant may be implemented as opposite party number 2 issue notice to opposite party yes
That might be fixed for
date will be yes.
mine.
Item 3.
My pleasure, Your Lordship. And sir, in this case, the compromise was held between both the parties, Your Lordship. I have filed in the joint affidavit, Your Lordship.
What is the offense
Offense is under section 341, 294, 323 and 34 of IPC, Your Lordship.
what are the allegations let's see
Allegation is that
final form is filed
yes,
No, my lord.
Let's
That's
say-
something.
charge is filed
let's say both the informant and the petitioner is present, Your Lordship.
Huh?
Both the informant and the petitioner is present in this court, Your Lordship.
Sai, what are the allegations let's
The allegations super, my lord. In the garage area quarrel, my lord. They have settled it. According to them, they have settled the my lord.
That belongs to same locality, Your Lordship.
Where-
Same locality.
where is Miss Rahul Singh Rahul Ranjan Singh and Kartik Shetty
Personal.
Kartik
The
Shetty
garage owner, my lord.
oh, he is the accused
He's
informant. Okay, at the instance of opposite party number 2, FIR number 2 came to raise against the petitioner. Petitioner the allegation is also the petitioner and opposite party number 2 are present in the court, being represented by their respective counsel and identified by them. They have also filed the self-petition copies of their Aadhaar card to establish their identity, which are taken on the court. The petitioner and the Uttam Kumar, who is
There are two
Uttam?
cases, my lord.
Some item, Your Lordship.
Right.
Two accusations,
Yes, Your Lordship.
separate case file. Inference.
One GRA.
Separately, huh?
Yes, Your Lordship.
The petitioner and the opposite party number 2 have filed a joint
One
affidavit dated 19/9/2024 inter alia stating as under para 2 and 3. From the query from the court, the opposite party number 2 submits that for maintaining peace and tranquility and on the intervention of the well-wishers clear settling the dispute, he wants to put a quieter to the entire dispute. And hence, he doesn't want to proceed to the case. Regarding head to the settlement and regarding head to the terms of settlement and the judgment of the Honorable Supreme Court in Gyan Singh also subjecting the petitioner to trial would be a futile exercise. Therefore, the petition legal merit accordingly the accordingly the FIR numbers also and consequent terms are quashed. So for files for second item, but cost
But garage, having a garage, my lord.
nahi accused
Informant having garage, accused went there and
accused has to pay 2,000. 2,000
Arjun.
DJ received the document.
Yes, sir. Yes.
both the cases allowed.
Obliged to.
Yes. Subject to goes to the accused. Yes.
Item 4.
May pillars.
And second case is also same FIR.
Another FIR one, my lord.
Same thing.
Two accused, my lord, file separate case.
Same GR.
Same year.
You are there or not, Uttam Kumar? Okay. Yes.
Yes, ma'am.
let's see if two proceedings against petitioner
Yes,
on the self-same evidence and self-same.
there are two FIRs.
Yes, my lord. Two affairs means, my lord, the one by the vigilance and another by the police.
For the same offense.
Same offense, one audit report and the 37 one amount. And
Which one you want first?
quas the subsequent.
Subsequent one.
The annexure
That
2,
is
my lord.
22-8.
Yes, my lord. Annexure 2 is the subsequent.
Let us see what are the, have you seen?
Yes, my lord.
Both the allegations are same.
Same, my lord.
The, my lord,
During
they are
my lord, see page 15, second paragraph.
15, huh?
Yes, my lord, second paragraph.
Yes.
The audit team detected the misappropriation of a particular amount during the course of audit on account of NSC district for financial of 21-22. Out of the misappropriation amount, some of this amount has been recovered during existing audit conference, leaving balance 37,000. And the my lordship will come to the
Second FIR.
yes, my lord. That's the page
But,
21.
apart from that, there are many other allegations.
other allegations are there, my lord. For
No,
that,
no,
my
what
lord,
other
This
allegations?
is one of the allegations.
No, no, one allegation, bro.
so for the
Huh?
clear case,
One
14,
allegation, bro.
No,
and
no,
they are
just
13, my lord. 13, my lord,
Yes, 13 is there, but 409 is both the cases.
but allegations are apart from the allegation which you read out,
Exactly.
Yes,
other
ma'am.
allegations are also there.
They are, my lord.
No, no, no. My lord, see,
The first FIR.
the 409 in both the cases, and the audit report is the best, based upon the audit report, both the cases, and the 2001 and 21-22. That the my lordship calendar belongs to page 21 below.
There are two investigating agencies.
Yes, my lord. Yes.
Vigilance case and the
You have
Vigilance-
not implemented vigilance.
and general police, my
Vigilance,
lord.
I'll serve the copy to the
You
vigilance.
serve the copy. We'll
Yes,
see.
my lord.
Compare it. If
Yes, my lord.
it covers, then one
Yes, my
FIR
lord.
may not
My
be
lord.
required.
Also 409 in both the cases, my lord. That's admitted in the both the affair.
CD, my lord, charge sheet is required, my lord.
Call for CD and
Yes.
issue matter. Yes. Next.
Till then, my lord, further posting, my lord.
No, no, no. Further-
Otherwise, trial will be concluded.
Nothing will have, it is at the very threshold. I'm putting it next week.
Yes, ma'am.
Yes.
I'll solve the vigilance copy, my lord.
And you have seen 2009, 2013, 14, stay orders are being taken in a cognizance order, it's pending.
No, before my lordship.
I'm not talking about you.
No, no,
talking
no,
about
no.
others.
When my lordship is dealing with this case, this will be
So
concluded.
I'll finish it up this
Yes,
way or that way.
yes,
See,
yes.
You just compare. If
Yes,
you don't need another FIR, why should you file
My
FIR?
lord, my lord.
One
Exactly.
FIR will suffice.
But so if charge sheet, my lord, I
Ah.
found some little bit, my lord, difference, my lord.
No, difference may be there.
Well-
If the subsequent FIR, the first FIR covers the subsequent FIR
Exactly.
offense
One,
also,
my lord.
why two FIR?
For that is, my lord, I required, yes, my lord.
Two agency,
Spare copy, my lord.
spare copy.
Yes,
please
ma'am.
keep.
I'll solve.
Please compare, I'm putting it next week.
Yes, ma'am.
Yes.
File this application to passing the cognizance in view of compromise law.
Yes.
The matter has been settled. Last occasion, you lordship directed both the party to present law.
Yes.
Both are.
I have not directed, but
Yes, sir.
therefore seek arrangement to for appearance of the
Yes,
party.
ma'am.
It's okay. You have sought the. What is the offense?
Offense 341, 294, 323, 506, 34. All are compoundable in nature.
Yes. Where are they?
Yes.
Devender,
Devendra.
Lakshmidhar,
Devendra.
Lakshmidhar, Narayan, Shiv Prasad. How many of you are there?
7.
Ashok Swai?
Yes. 9.
Huh?
Informant is there.
Inform करते injured पे particular नथले.
Injured, who is injured?
Dilip Kumar Vishwal are there.
Is the informant. Dilip Kumar Vishwal is informant.
Is there.
And who is the injured?
Injured nahi. Injured.
How?
Just see who is injured in the FIR.
Sarada
Tomorrow he'll
Prasad.
come
Mahadev
and challenge it.
ମୋ ପୁଅକୁ ଗ୍ରାମବାସୀ ଉଦ୍ଧାର କରି ଦେଲେ। ପୁଅ ପରା
Father is present, Lord.
father ପୁଅଟା ହେଲା injured।
Who? What is the age of the son?
କଣ ପୁଅର ବୟସ କେତେ?
ଶ୍ରୀନିବାସ ବିଶ୍ୱାଳ ଲୁହା ରଡ୍ ବାଡେଇଥିଲେ। ପୁଅ କାଇଁ? ପୁଅ ଆସିନି ଆଉ।
ତାଙ୍କ ବାପା ଆସିଛନ୍ତି. They are the informant.
I don't know.
Oh,
That
that
son
will-
will
that
come
will-
tomorrow. That my father is
Last time the case urgent for that is
No.
only included the
2 o'clock. You bring the son.
He is injured, madam.
Let him
Srinivas
clear.
Biswal, the more po Srinivas Biswal को लोहा छड़े आक्रमण करथिबा समय
He is injured.
शारदा प्रसाद दास
I pray, my lord, lordship, जो informant petition appearance to allowed me record.
No,
And
no, I will not doing insolently. At 2 o'clock, you bring him in a VC. Then I'll take
it
it
is
up and finish it up.
it is impossible to
12 o'clock. 12 o'clock.
Basic code is
Why? Don't say all these things. 12 o'clock?
your lordship urgent to next.
No. Why? So many people have come. I will finish it up. VC. Why unnecessary?
Yes.
All right. See, I just want to his presence. I will record. That's all. Otherwise, tomorrow it will be a problem for you. 12 o'clock.
It's not 12.
12 o'clock. You tell him to just appear. I'll record his presence that through VC mode he has appeared. 12 o'clock. Okay. 6. Yes.
May I please, your lordship?
Yes.
Well, my lord, the petitioner challenge, the impugned order is at annexer 7, my lord.
7.
Aye.
Yes.
Wherein the discharge application was there and this has been rejected
Yes.
under annexer 7. It is the relevant page is page
Mysore Satvati.
I am Mysore Sattva.
Okay. 7. Yes.
Only on the my limited submission is my lord. This petitioner while
And
work,
you only moved the application, the other accused have moved the application. There are 13, 14, 15.
14 persons, but the
All of
real-
them moved the application for discharge.
No, I myself. It is at the best of the present petition.
Yes. 227 applications moved by you. Yes. Yes.
Only on the ground that I was working as a senior divisional accounts officer. So all the allegations so far the FIR is concerned, 2 successive FIRs are there. It is a 57 and 50. I have not been named in the FIR. So far the codal provision of the senior accounts officer is concerned, I was in charge for a particular period. It is not my responsibility so far the inflated measurement is concerned. Measurement part is not coming within the purview of a accounts officer, my lord. Apart from that, I was for a little bit time I was in charge. That is also annexer 2 and annexer 4. Thereafter I have been. But the person who was in charge of the same, he has been exonerated and proceeding has been quashed. On the ground, that lack of sanction of prosecution, 197. On that score, technical ground, he has been left from this charge.
Sanction was not granted.
Miller?
Sanction was not there.
Yes. On that score, he has approached this honorable court and he has been scot-free. But
That
I am
is
the
sanction.
person, exactly. I am the person, along with others, on the ground, even though not named in the FIR, subsequently in the additional charge sheet, I have been implemented.
Come to the charge sheet where
Yes.
your allegations are there.
It is at annexer 3 at
3.
page 28.
If allegations are there, it has to be tested in the trial only.
And and more particularly, the person has retired since 2014. After lapse of 3 years, this charge has been framed. And
Therefore,
as of now
therefore,
also,
the sanction was not required. They might be saying that.
so I am suffering from cancer and counting my days. At this juncture, neither it is commenced.
You are on
the
bail.
trial-
You are on bail.
Yes, I mean, it is at page 43 kind of moment.
Please.
43. So far the charges are concerned. I am Master Satpati.
No. Come to the allegation in charge sheet.
Yes, ma'am.
Where is that?
It starts from page 3, page 28.
Relevant part is this one. Yes. Come to page, what is it? 67, 66. Come to page 62.
The brief fact is at 66 page.
Yes. Read. What is your name?
My name is Mysore Satpati.
Maybe digging a production wall.
I am at serial number 1, 2, 3, 4, 5th para.
Digging of
The duties of a divisional accounts officer are to assist the divisional officer in the discharge of his responsibility as to account of financial regularities of the transaction of the division. Basically, the division accounts officer has threefold functions. One is compilation of the account, internal checking, and financial advisor of this division. This much. So far, the codal provision under the OPW Act is concerned also, that I have quoted. This is never coming within the purview of.
Where is your name in the scheme of this thing? Where does your case, your role is
So far,
described?
my name is
in the
at
charge sheet? You are responsible for allotment of funds.
allotment of
Funds.
my work has been assigned like this manner, OPWD code. Page 67 for a moment.
You are not showing me the relevant part. I am searching for that.
Page 77. 76 for a moment at the top, from the above.
See, 120B is there. See, it needs to be tried. You can't help it.
I'm no concern. So far, this my official.
That will be sorted out there in the trial only. How will I segregate it today? The allegation is a composite allegation.
And prima facie, so far this affair is concerned, there is no allegation, nor out of this 12 and 8 persons are there, but I am not been named in the affair. In the two successive affairs are there in 2009, 57 and 58. And so far the nature of work is concerned under the codal provision, I am also no assigned to this work. More particularly, I was for a particular period, I was in charge of the things. So far the divisional accounts is concerned.
Should I record my one submission, my lord? At best, all the submission, my lord, if accepted, my lord, can be turned as defense plea, my lords. Those are required to be
I can't segregate things. The allegations are very composite.
Factual aspect has to be adjudicated by addition evidence to that.
Today I have to conduct a mini trial to find out what is your role.
That is prohibited, my lords.
It is apparent on the record itself. So far, my
but you are not able to show me where is the charge sheet, where does
they at the same time, so far the charge sheet.
I have been searching, show me where you are not able to show.
My lord,
then I'll have to read the entire.
Page 76 for a moment.
76 I read, I've seen it. 76.
Nowhere specifically they have given this.
So, but it's 120B. The money is, you are in account.
But it is within the scope and ambit. So, money is concerned.
Is there. I can't segregate things now. At this stage.
Can I pray for this early disposal of the trial?
That I can very well see.
Because I'm in disgusted because since 2014 I have retired. I'm fighting with my last breath because I am suffering from cancer.
No objection.
At this juncture,
on that plea, my lords, I agree with my lords. Because of his special situation, my lords.
27.
Let him get
24, whereby the application under section 227 CRPC for discharge has been rejected. Mr. Satyabrat Mohanty, Lieutenant Counsel for the petitioner, has taken me to the allegation made against him in the FIR as well as in the charge sheet, and urged and submitted that by accepting the allegation at its face value, no case against him is made out. I have perused the record carefully and analyzed the evidence form part of the charge. I'm of the considered view that from a considered review that the trial court has rightly rejected the application under section 227 CRPC for discharging the petitioner because because the allegations are of alleged offense under section 120 capital B IBC, but besides other penal laws. It is impossible to segregate the role attributed to the petitioner by the prosecution at this stage, and it is inevitable for the petitioner to face the trial and face the trial so as to establish the role and the statement. In that view of the at this stage, Mr. Mahanti submits that the petitioner is suffering from cancer. And he has a terrible health condition.
And he retired since 2014.
And he has already been retired since 2014. 2014. Hence, he seeks indulgence of the court for expedient restoral of the trial.
Because of that ailments, my lord, lordship may direct them, lords, to expedite the process of trials.
I will allow for 205 also you move up.
Yeah, no problem.
Because his health condition.
Exactly, my lord. Because of that particular aspect, my lord, I agree with you.
Needless to say that petitioner being an accused has a constitutional statutory right for free, fair and speedy trial.
As expeditiously as possible.
Therefore, the trial court is directed to do well to see that the trial is concluded as expeditiously as possible. Owing to the
ailments
condition for the present petitioner, the petitioner is also given liberty to move application under section 205 CRPC for exemption from
317.
For personal appeal.
Representative.
Personal appeal. If such application is moved, same shall be considered in keeping in same shall be considered sympathetically, keeping in view
serious ailments.
Serious ailment being suffered by the petitioner. Okay.
Okay. Can it be observed that the person who was in charge of the day, he has been exonerated?
Merit item. Merit item.
Diploma.
I have given that 205 and everything because of your help.
Okay.
Yes. Yes, bail.
7.
Yes, sir.
May I please your lordship? The last occasion, lordship has been pleased to produce the evidence of the.
What is it? 1, 2, 3, 4, 5, 6, 7, 8, 9.
373 is there.
9, 10. 10 hearing for a bail application.
Yes, I am for the informant through legal aid, my lord.
Legal aid. Okay. What are the allegations? Let us see. 164.
Evidence already recorded, my lord. Yes, should I read it?
Evidence when recorded?
My lord, recorded, my lord. 9/8/2024, my lord.
9/8?
22/3/24.
22?
22 years service. 22 years service.
22 result. Okay. Okay. What are these? Yes, read it out.
Well, I am the informant victim. I know the accused such and such. The alleged incident to occur 23/10/2022. There was a 21st day celebration at the village Jammu, for to which I had been attended. At that function, I had met with the Harish Chandra, this petitioner. Some days after, Harish Chandra visited to our house and told that he is in love with him. My victim is about when evidence recorded, my lord, 13 years, my lord.
Yes.
Love with him on 23rd 10/2022. Harish Chandra Sahu.
22/11/2023. The matter was taken up for hearing on 31st July 2024. And on 23, matter was taken up on 9/11/2023 and on 31/7/2024. None appeared for the petitioners. On the subsequent date also, none appeared. Yesterday, the matter was taken up, even on the second call, none appears. Today, when the matter is taken up, again, none appears for the petitioner. In that view of the matter, I am not inclined to entertain the petition. However, liberty is granted to the petitioner to renew the bail plea before the court. Yes.
Nice.
May I please, your lordship? 50 kg ganja was seized, my lord.
Much?
50 kg, my lord.
50.
My lord.
Custody?
And custody 13/8/2023, my lord.
13/8/2023.
2023.
Granted bail. Subject to verification.
My
Three cases. Three cases.
All the three.
No. So I am for BLPL only.
I am for subsequent.
Another accused. Same FIR.
Same FIR, my lord.
Same order. Same order. There are three accused in the present case. The 50 kilo of contraband ganja was recovered. Petitioner is in custody since
13/8/2023.
And in what about the second? Other two, same day?
No, my lord. They are after custody since for Ramo alias Ramu Hantalo on 11/4/2024.
Ramo Hantalo,
11/4/2024.
11/4/24.
My lord.
Yeah, you are absconding or what?
My lord.
Absconding. And what about?
And the other is 21/1/2024.
21/1/2024.
24.
First allow karo, second adjourn karo.
There are two cases. First case is man of Andhra Pradesh.
He's Andhra Pradesh.
Andhra Pradesh, man.
He will never come.
My lord.
That's another problem. That's the biggest problem.
Stringent condition.
Stringent any condition. Once you go, no stringent, nothing. Local security.
My lord, item.
And I am having no antecedent.
Huh?
I am having no antecedent.
Sorry?
I am not having antecedent.
My lord, page number 13.
And local security, and he shall appear before the IIT. Which police station?
My lord.
Kalimela police station every month. In the last Sunday of every month. Last Sunday of every month. Yes.
My lord, page number 13, my lord. Kindly see page number 13.
Which one?
This.
There are
other two cases.
Sub item, my lord.
Sub item.
Which case? 31. There are two cases. Which one?
6637 and 666751.
Page 13 of which petition?
Both are, my lord, same.
Same page. Okay, 13. Yes. What do you want to do?
Line number 7.
13.
7.
Yes.
By means of four-wheeler and the R. Rajaram was guiding those two ganja packets. Packet 6 at the court at the instruction of Hon'Ble and Ramo alias Ramu Hanta. He also disclosed that on Raju named person of village Gila Mandigiri near Niman Kolam. In this case, I have no, my name does not reflect. The coercive statement I am reflected as an accused person.
In case of Ramo Hanta.
No, my lord. Korayapola. In 6637.
Okay. What about Ramo Hanta?
Ramo Hanta was named as per the version of the principal as Rama.
Yes, Mr. Same thing. Right.
Same ganja, my lord. First petitioner sold to second petitioner, second petitioner carrying the same.
50 the in Ramo Hantala it is alleged by the prosecution that the 50 kilo of contraband ganja was being carried by the principal accused R. Rajaram. And he has disclosed the name of the present petitioner. Being an accomplice.
No, madam. 3 persons head out from this spot, and the police able to cut out that person, and he disclosed.
there are three activities. When the police tried to apprehend them, all of them fled away. However, the principal, the accused Rajaram was apprehended at that spot. On his disclosure, the other two accused persons, including the present petitioner, has been implicated and subsequently arrested. On Raja Hantalo Keve? Rama Hantalo was apprehended. Rama Hantalo apprehended on 11 2024.
On this
Whereas Karaya Palasi Karaya Palasi on 11/4/2020. 21/1/2020. 24. Granted will subject to verification and local security. Insofar as the first matter is concerned, he has to appear before the IIC so and so every month on the last Sunday. Yes.
Deeply.
All the three.
Antecedent will verify. Madam.
Antecedent
They
verification. I don't tell all this thing. I'll reject it now. Otherwise.
Tell.
Yes. Then
In this case, my lord, I'm appearing on behalf of the informant, my lord.
informant.
My lord.
Lordship,
Yes,
as
madam.
for the petitioner, Lordship, I'm appearing on behalf of Mr. Sangram Das. He has been taken ill and
Adjourn on request. Yes.
Lordship, meanwhile, we have received, we applied for the certified copy of the victim.
You file it.
declaration. We filed this. Bless you. Lordship.
Request. Go to November end. Yes. 11.
May I, Lord?
May I please, your Lordship?
My Lord, I will refer to the 164 statement of the.
Yes. You are in custody since?
I'm 22nd August 2022. 23.
23. Okay. Yes.
My Lord, that 164 statement of the victim, that is in page 68, 69, 70.
Read it out, sir. Read it out.
Hello?
164. Read out.
That is the victim. 164 statement of the victim.
I know. Read it out.
Pardon. So, well,
Mr. Agada will read it out. Wait. Yes.
ମୁଁ ପ୍ରିୟଙ୍କା ସଚାର ସଚନା ଗଲା ଜିଲ୍ଲା ବଲାଙ୍ଗୀର ଉପସ୍ଥିତ ହୋଇ ବୟାନ ଦେଉଛି ଯେ ମୁଁ ଧବଳେଶ୍ୱର ସ୍କୁଲରେ ପାଠ ପଢେ ମୁଁ ଦେଓଗ୍ରାମର ତୁଷାର ସୁନାକୁ ଭଲ ପାଏ
19 years. The boy is 19 years. Right. Petitioner is accused in front of this and allegation is the The statement of the victim girl under section 160.
Notice statement, notice of sent.
That is the notice was issued to opposite party. The informant oblique victim despite sufficient service, none appear. Right. Properly, the statement of the victim, who is stated to be what is age?
Age, my lord.
13. Stated to be 13 years of age was recorded under section 164 CRP. She in her statement has stated that she has been in a relationship with the petitioner and they had physical relationship. They had physical relationship. The petitioner is petitioner. 1 minute. The petitioner is about 19 years of age. Petitioner is about 19 years of age. He is in custody since 22/8/2020. Regarding to the nature of petition and age of the petitioner being 19 years and the period of custody from 22/8/2023, I'm inclined to enlarge on. Yes. Yes. Next.
Item 12.
Adjourn on request.
Item 13.
Yes.
Permitted to withdraw.
Then quote below. How can it be if the matter is pending here? No. If the matter is pending here, how the trial court has granted bail? You might not have disclosed that matter is pending here. No, you, then I'll recall the order. If you have misled the court. You show me, the same thing happened, Mr. Chand appeared on that day. Mr. Chand appeared on that day, the same thing happened. Matter is pending here, he got, and filed the petition, the, where have you said that has been released on by the learned court below? Get that application. But you are the lawyer. So then you need to know, ask them whether the trial court, they move the trial court, whether they have informed that the matter is pending before this court.
Lordship may call for a report from the district court, whether they has given certificate or.
Madam, a petitioner seeks to withdraw the present petition on the ground that during the pendency of the present petition, the trial court has granted bail to the petitioner. Call for a report from which court? Which is that court?
The additional district session judge, cum special judge, Pokso,
Jajpur. Monday. Yes.
Item 14.
May I please your lordship, the petitioner has been acquitted, my lord.
Yes, in fact, yes.
Item 15.
15. Yes, sir, 15. Last time none appeared.
CDL has not come, 373 is there.
372
no, CDL is not come. CD.
It is not, hasn't come.
Who gets
In the on the last date of hearing, that is 8/8/2024, none appeared for the petitioner. However, in the interest of justice, matter was adjourned to and direction was issued to the State Council to obtain case diary. The case diary, none appears for the petitioner even today. The case diary, Mr. Ragada submits that he has not received the case diary in the interest of justice adjourned to December. Yes.
16.
May I please, Lord? 326. 506 with 34 of the IPC, custody is 3224. 3224.
Yes.
Father-in-law throwing acid, my lord, towards his son-in-law, since he was tortured the daughter. The injury is grievous in nature, custody, my lord, more than 7 months.
Yes.
Your matter, the injury is that yes, my lord, he has thrown, he's a goldsmith. The present petition is a goldsmith. He has thrown the acid to the son-in-law.
There is injury in the eye.
Injury on the eye. Your lordship directed to whether the, but it was ascertained that the victim is not able to see clearly due to it. This is the instruction.
Clearly, jil dekha jaata.
Might have been lost his eye.
Not lost. Your lordship call for a report from the concerned doctor.
That is a
report. I am giving you liberty.
Your lordship call for a report from the doctor, my lord. His vision is not.
1 minute, allow me to write now. The petitioner is the father-in-law for the victim. Due to the family dispute, the petitioner has poured the acid on the face of the victim. I have sought for a report. There are the victim has sustained burn injuries, and which are grievous in nature, and he has received an injury on his eye, left side eye. I sought for an this court has sought for an report from the IIT regarding the nature of the injury caused to the eyesight of the victim. IIC Odoba PS has submitted a report dated 17/9/2024 inter alia stating as with reference to the case inverted comma with reference to the case and subject cited above, I have the honor to state that conducted local inquiry from which it is ascertained that the victim is not able to see clearly by his left eye. As per the advice of MO, he is using spectacles and which may improve the eyesight of the victim when the victim in due course of time. In view of the nature of injury sustained by the victim, I'm not inclined to.
No, your lord, 7 months is in custody, my lord, 326.
Since the petitioner is in custody since 3/2/2024, the petitioner is granted liberty to renew his bail plea before the court below. If such bail plea is moved, the same shall be considered on the basis of material available. Next, yes.
17.
Your lordship. Yes,
Wherever bail is there, I am granting.
Don't worry. Pura visible only, that is.
I am not going to ask him. You
Well,
know,
your lordship, direct.
You know, acid is banned, you know.
Yeah.
Then
say goldsmith.
Therefore, you have easily available acid, sulfuric acid, and throw in the base of someone.
I'm
just wondering how 307 is not made out.
That sheet submitted 326.
That is wrong.
It
should have been a case of 307 straight away. Yes. Nature of injuries are very yes. You renew the next.
Yes.
Item 17 I will be permitted, my lords. My lords, from record it appears that the petitioner was arrested on 6/5/2018, my lords.
6/5, huh?
My lords. And your lordship kindly note, my lords. He was granted interim bail on 25/3/2019. In between, he had remained in custody for 10 months, my lords. After 10 months of custody, he was granted interim bail. And after interim bail, he absconded, my lords.
For a period of 4 years, my lord.
I'm submitting, my lords. I'm not. Let me finish.
Thereafter again you apprehended.
Yes. Yes, I was arrested on 9/1/2024, my lords. I was arrested, again arrested 9/1/2024. After that, I have remained in custody for 8.5 months. So total period of custody is 18 months, my lords. 1 year and 6 months, my lords.
What is the offense?
Offense 363, 376.
For Boxo, my lord. For Boxo, my lord. For Boxo, there, my lord.
For Boxo.
34 years. Victim, my lord, aged about 16 years, my lord. He had released on interim bail and absconded and apprehended 4 years after 4 years, my lord.
Petitioner.
Report only confirmed that is fact. A, my lord.
Report you also confirmed. I know. I have seen. Petitioner is accused and so on. Initially, the petitioner was arrested on 6/5/2018. He was enlarged on interim bail on 25/3/2019. He has misused the concession of interim bail and did not surrender. Subsequently, on 9/1/2024, he has been apprehended. Since then, the petitioner is in custody. The petitioner is a 34-year-old man, and the victim is
16 years.
16
at the time of recording of
regard being had to the nature of accusation and the conduct of the petitioner, I am not inclined to enlarge the petitioner on bail. Accordingly, the same is dismissed.
My lords, liberty may be granted, my lords, if there is inordinate delay in conclusion of the trial, my lords.
Land cause for the petitioner submits that in total, the petitioner has already in custody since about 18 months.
Yes.
18 months. In view of the same, liberty is granted to the petitioner to renew the bail plea before the trial court. If such application is moved, the same shall be considered on its merit on the basis of the material available on the court. Yes. Interim, but he says that he stayed from 6/5/2018 to 25/3/2019. Yes.
18.
Yes.
May I please your lordship?
Yes, sir. 18.
My lord, offense under section 20B(2)(c) of NDPS Act and illegally transport of contraband ganja of 100 kg.
100 kg.
Yes, my lord.
Custody since?
Custody since 10th May 2023. And your lordship has order on 13th July 2024, registry is directed to call for a report from the consent court with regard to the progress of the in trial.
Yes.
In this regard, the instruction has been obtained, my lord. It is found that aforesaid case is sent to the court Hon'Ble First Additional District Session Judge Cuttack and posted to be trial on 28/24. Just recent as 28/8/24. Trial started. Petitioner belongs to the out of state Uttar Pradesh, my lord. Petitioner belongs to the out of state, my lord.
There is a report that the witnesses are summoned.
Yes, my lord.
Summoned, right on. Petitioner is
My lord, any outside condition, including case
No,
security.
you are an outsider. Wait, I have seen the report, and after 6 months you renew the bail.
My lord, kindly permitted to withdraw.
He is in custody since 10/5/2020. This court got the report from the court below. The report has been.
My lord is praying for withdrawal, my lord.
You want to withdraw?
My lord.
Then counsel for the petitioner seeks to withdraw the petition. Yes. Next.
19. May I please, your lordship?
Yes.
Your lordship, the petitioner is charged under section 376(2)(n), 376(3), 365 and 6 of POCSO Act.
Yes.
In custody since 4/5/2021.
4/5?
2021.
21. Yes. Read 164.
My lord, already the victim was examined at PW5. Last occasion, coordinator bench also directed to submit that deposition copy. Last occasion, lordship also directed to submit that deposition copy.
Where is that?
I have not yet received, your lordship.
Then you renew the bail plea. What can I do? You don't file. Repeated directions are made.
If
So,
I correctly
so many
remember,
years.
She is ready to marry the petitioner, my lord.
The-
And you are also asking the counsel for the victim, whether victim is ready to marry her or not.
But she has already given birth a child. That
she
minor
will-
girl has given birth a child.
Petitioner ready, but his family member is disagree.
No, that will be decided in the court.
But Pillar he for that you know, last occasion I asked him whether both are ready to.
The boy is 20 years. The girl, what is the age?
My lord, at the time of incident, both were juvenile, 17 or 16.
ସେଥିପାଇଁ କହିଲ
ହେଇଥିଲା ଯେ କିନ୍ତୁ ପିଲା ଅଛି କିନ୍ତୁ ତାଙ୍କୁ ଏଇ ତ ଘରେ ପୁରେଇ ଦେବେନି।
What can be done? You tell me.
Sir, my lord, in that regard, in last occasion, your lordship, the petitioner counsel has submitted intend to file the interim bail, my lord. For which by this process he can marry.
But the petitioner's parents are not agreeing to it, your lordship. Then
For interim bail.
For interim bail even. They are not ready
They
to
want that
accept
he should be there in the jail.
They are not ready to accept the victim. So what can be done, your lordship?
It's a very difficult situation.
Even now.
And he may renew his prayer before the court below. On the purpose of marriage, if the application will file before the court below, it will be considered.
The parents want that let the boy be there inside, but we will not bring it.
The welfare of the child should be taken into consideration. One thing. And both are young, my lord. By the time they.
That's right. He is entitled to bail.
Exactly.
But the problem is once bail is granted, same thing will happen. The pressure goes.
Exactly.
So interim marriage.
He has to move application.
There is some ill intention.
Victim ready, but the parents of the petitioner.
You renew your bail plea. Let counsel for the petitioner submit that in I record it and trial court will consider the interim bail application. On all these things, I'll record and right away. Petitioner is accused in so allegation in the petitioner so. It is submit the counsel for the informant victim submits that the girl has delivered a baby. Girl child. The petitioner is a 20-year-old boy, and the victim is also 19 at this. 19 years.
Victim 60 years.
Now.
Now, if he is 20, He's 19 because 1 year gap is there. 17, 16 at the time of occurrence.
So now he's
Now
major.
19 major.
He is major. He is 19 years.
Major.
Major.
18 years.
But at
18
the time of,
years.
at
18
the
years.
time of incident, the petitioner was also a juvenile. Petitioner was also juvenile. During the pendency of the present petition, the victim has already been examined in the court, examined by the prosecution. In view thereof, I am of the view that the petitioner should renew the bail plea before the trial court. The trial court shall consider the bail plea within 15 days of moving the thing. Then counsel for the opposite party submits that the petitioner submits that he is ready and willing to marry the girl. However, the parents of his parents are opposing for the same. In that view of the matter, the counsel for the opposite party submits that the petitioner shall be released on interim bail, and he shall be given an opportunity to explore the possibility of marriage. Since I am not inclined to entertain this bail application, I am giving liberty to the petitioner to move interim application for grant of interim bail before the trial court. If such application is moved, same shall be considered in the light of the submission made by the parties before this court. With this observation, the petition is postponed. You move an application there, interim, I have said that, and you get interim bail, then there may something may happen. Okay. Your parents want that you should better you stay in the jail, but we will not allow this girl. And the problem, the father of the victim girl has no option.
I understand.
He wants that at least his daughter should get married. See, this is the very
obviously, because nowhere she will be married to any other person.
Actually,
except
there is
the
a child.
petitioner. There is a child.
Yes, yes.
20, and her age is 18 years right now. 18 years.
A major child.
18 years.
Here the alleged offencer under section 376, 2N, 379, and the
Custody?
6/7/2023. 6th of July 2023, madam.
Yes.
Boy is 32 years, whereas girl is 29 years. And it is the case of the prosecution that both came in contact through social media, and thereafter, my lord, both of them has exchanged their number, and in this process, acquaintance developed. Thereafter, it is also alleged that in
have you taken nude photograph?
My lord, my lord, I am coming.
Identify?
Yes, identify in front of the in front of the court.
Will identify.
Identify.
He in another court, not.
I don't understand. At the instance of opposite party number 2, the FIR number 4 has also been to be registered. The allegation against the petitioners are such. The petitioners petitioners and opposite party number 2 are present in the court and represented by their respective counsel. They are identified by that. They have also filed some copies of other cards which are taken under court. The petitioner number 2 is opposite party number 2 is the father of the victim. Father of the victim. Father of the victim. The victim. Vishwa is present in VC. And he also he completes that he has no objection if the criminal prosecution is dropped against the petitioner. Affidavit
is there, my lord.
Yes. The opposite party number 2 has filed an affidavit dated 15/5/2024. It is not even a one-page affidavit. It's a less than a half a page affidavit, saying nothing. Except your name, that there is nothing.
The matter has been settled.
Why are you doing all this thing? I don't understand.
Sir.
At least
What is
file
settlement?
one-page affidavit. You are settling the dispute. What is this affidavit? You accept your name, there is nothing. You people have reduced down this High Court to this level. I don't understand. Just read your affidavit. What have you written?
That as the present
The
petition,
present petitioner, this is the only paragraph you have written, that as the present petitioner and myself are of the co-villager due to interference of our villager people and also our well-wisher, the matter is compromised. Finish.
but it is made before the oath commission, Lord, so that
I'll impose heavy costs for this. I'll pass it, but impose heavy costs.
all are poor person, Lord.
In the said affidavit, except the fact that the parties have settled the dispute, nothing is mentioned in the, nothing is mentioned. The opposite party number 2 is present in the court. From the question, what is the settlement, terms of settlement? Ask him.
term of consideration ପଇସା ତ ଦେଲା କଣ କମ୍ପ୍ରୋମାଇଜ କୋଉ ଦିନ
And the query from the court states that well-wisher and villagers have intervened in the matter, and intervened in the matter, and to maintain peace and tranquility in this area, he wished to put the quietness to the entire dispute. Can we put it in representing the opinion of petitioner and all the petitioners and the opposite party number 2 are present in the court during the respective counsel. They filed their self-addressed copies of other cards. Regarding that to the fact that the parties have settled the dispute, and then in view of the judgment of the granting of the Supreme Court, subject to the trial definitely be a futile exercise. Therefore, the petition is liable to be allowed. Getting the file number from passed, subject to the petitioners paying 1,000 each to the respondent. 1,000 is to the opposite party number 2, number 2, and paying 5,000 rupees cost to be deposited with the High Court Bar Association. 1,000 rupees each you have to give to the opposite party number 2, and 5,000 you deposit in because of the manner in which the time of the court is wasted. Therefore, you pay.
All are poor person, there are villager co-will.
Then poor, then you conduct properly. You want quashing and you don't say anything. Still I am quashing it. Otherwise I would have dismissed it. You pay the cost for that. Yes.
21.
Yes.
376 2N and 6 of POSCO acknowledged. Inside custody from 16 to 24 miles.
16 to
24. The girl was 17 and a half years, the boy is 24 years miles.
Yes.
The girl went with him in constant manner. 164 statement is also there.
Yes, just see. 164.
Yes, my lord.
Yes, read it.
ଅବିନାଶ ସେଠି
ମୁଁ ଅବିନାଶ ସେଠୀକୁ 7-8 ମାସରୁ ଚିହ୍ନିଛି। ମୁଁ ତାକୁ ଇନଷ୍ଟାଗ୍ରାମରେ ଭେଟ ହୋଇଥିଲି, ଆମର ଫୋନରେ କଥାବାର୍ତ୍ତା।
This is the third time.
And it is made clear that no further adjournment in this pretext.
Yes,
granted.
Yes, ma'am.
State, yes.
23.
Yes.
ମୁଁ କିଛି କହିଲି।
Yes. 23.
May I please, my lord?
Yes.
My lord, 376 and 6
Unbroken.
Cosco, my lord.
Hmm.
The victim who went with the petitioner stayed in a hotel. In 164, what she has stated, जे चांदबाली बाइक रे नहीं एक होटल को गले सेतेबेले
You are 31 years.
my lord, yes. And
Girl is
164.
girl.
girl is 16.
Girl is 15 mile.
He has received the evidences of the witnesses, which is it has been filed here.
Lordship.
Where is that?
11 witnesses I have
No,
already.
where are they? It's not filed.
I have filed.
It's not. It's not there. You filed it, huh?
Court refiled.
Witnesses. He received the evidence of witnesses in the court. Even I thought therefore he seeks one is for what this the evidences are also not placed on record. The counsel for the petitioner is directed to place on record the evidence. Is the matter of yes.
25.
Date fixed, Lordship.
The date will be fixed. Yes. Next.
May I please, Your Lordship?
Yes. Yes.
Petition is in custody, my lords, 24/4/2023, my lords, and charge sheet was submitted offense under section 294, 341, 324, 307, and 506 of IPC, my lords. And due to previous dispute between parties, subsequent FIR has lost, my lord. And as per my instruction, injuries are grievous in nature, my lords. My lords.
Injuries.
My lords, grievous in nature, my lord. That is the admitted fact, my lord.
307.
307, charge sheet submitted 307. And petition.
CD has not come, but your
Call.
Lordship may kindly have.
20
Call for CD next week. Yes. Next.
26.
26, my lords.
Yes.
Charge sheet was submitted offense under section 373D of IPC. This is not a compoundable offense, but in the meantime, my lords, petition matter was amicable settled between the parties and informant was present and filed an affidavit before this annual court, my
This
lord.
is item number 26.
26.
My lord, 376 deed, my lord.
Yes, my lords.
And the
Last
CD has
occasion
not
was-
come. CD has not come, my lord, your Lordship.
Call for CD then. Next week. Call
And also, my lord, kindly, my last occasion lordship directed to go whether the matter was amicable settled between the parties or not, take instruction to the state council, my lords.
Yes.
Yes, you have to
Yes.
verify. The
Yes, ma'am.
land council for the petitioner submits that the parties have settled with the dispute. The victim prosecutrix has filed an affidavit before this court regarding the same. And the state council is to verify this aspect through the IO of the present case and submit a report, release the matter 1 week after. Yes.
Okay, may I please, Your Lordship?
You are appearing for the prosecutrix. You are appearing for the.
I am.
May I please, Your Lordship?
27, huh?
27, my lord.
Yes.
Initially, my lord. Initially, in this case, my lord, registered under section 363 of IPC, my lord. Subsequently, after filing the charge sheet, police added under section 363, 372 and 373 and IPC and under section 6 of the POCSO Act. Here is my lord, petition is in custody.
Preliminary charge sheet has been.
Preliminary charge sheet, yes.
Your Lordship, I may be permitted to read out 3/161 statement. If your Lordship will allow me, I'll read.
You are the husband?
Yes, your Lordship.
Yes, ma'am.
Yes.
It
is there?
Yes, ma'am.
Deceased ର ଭାଉଜ ର statement. ମୋ ଝିଆରୀ ରାଧାରାଣୀ ବେହେରା ବଡ ସେ ଗ୍ରାମର ଦୀପକ ବେହେରା କୁ ପ୍ରେମ ବିବାହ କରିଥିଲା। ବିବାହ ପରେ କିଛି ଦିନ ଭଲରେ ଥିଲେ। ଝିଅଟିଏ ହୋଇଥିଲା। ପରସ୍ପର ଚରିତ୍ରକୁ ସନ୍ଦେହ କରି ଏହି ଘଟଣା ଆଜି ଘଟିଲା। ବହୁତ ଥର ଦୀପକ ମୋ ଝିଆରୀକୁ ମାଡ଼ ମାରିଛି। ଆଲୋଚନା ହୋଇଛି, ସମାଧାନ ହୋଇଛି। ଦୁଇ ଜଣ ଯାକ ତାମିଲନାଡୁ ପଳାଇ ଯାଇଥିଲେ। ସେଠି କାମ କରୁଥିଲେ। କଣ ସେଠି ଆମ ଝିଅକୁ ସେ ସନ୍ଦେହ କଲା। ଘରକୁ 9/10/2023 ଡେଟ୍ ଅଫ୍ ଅକରେନ୍ସ ଫେରିଲେ। ଫେରିଲା ପରେ ପୁଣି ଘର ଭିତରେ ଝଗଡା ଲାଗିଲା ପରେ ସେ ଝିଅ ଘର ଛାଡିକି ପଳେଇଲା। Subsequently, near about after 3 meters far away from the house of the petitioner, the dead body of the deceased found there.
How she died?
Strangulation, my lord. This petitioner has expressed in 27 statement, my lord, and the matter has also supporting to the postmortem report, my lord, regarding the strangulation and pressure on the neck, my lord.
Because of sudden provocation, your Lordship, a 5 years old girl is there out of their wedlock.
Sudden provocation is total.
Nahi. As it seems from the statement of the Bhauja. Your Lordship, another statement is the social say
How many witnesses are there?
There are, my lord,
Material witness.
all the witnesses are interested witnesses. Altogether, there are 6 number of 13 numbers
out
of
of 13 numbers, my lord.
Huh.
Material witnesses, my lord, 10, 8, my lord.
8. Yes. You wait till material witness. Wait now.
May I pray what charge has
I have the statement of the witnesses recorded under 161 CRPC were made over extensively by the council for the parliament. The overtake attributed to the petitioners are very specific. The things are therefore not inclined to be on bail. However, liberty is granted to the petitioner. So we need to after the judgment of the argument, the trial court is directed to do to see that the maintained argument is preferential over all other witnesses. Regard being had to the period of custody from 12/10/2023. The petitioner is also given liberty to renew the bail plea after the 6 months if the trial is not proceeded at an expected pace. With this observation, the petition is disposed of. Yes, next.
29. My lord, item 23 permit to withdraw.
Withdraw. Yes.
Item 30.
30.
May I please, Lordship?
Yes.
Alleged offence is under section.
Yes.
450 and 376 of IPC. History in custody.
Traffic filed?
450 and 376 of IPC.
Traffic filed?
Yes, madam.
When?
Yes.
Yes, my lord. Charge sheet has been filed on 10/05/2024, my lord.
Okay. The rejection is on April.
164.
Right, and petition is agreed by the order dated 29/4/2024, whereby his bail plea has been rejected. Subsequent thereto on 10/5/2024, charge sheet has been filed. In the changing circumstances, petitioner is given liberty to renew the bail plea before the court of first instance.
Yes, ma'am.
If such application is moved, same shall be considered on the basis of the material which are form part of the charge sheet. With these observations, petition is. Yes.
31.
Yes.
May I please?
Yes, sir.
A poor handicapped person, he has been entangled.
Huh?
A poor handicapped person, he has been entangled in the stand case. Those he has
Custody.
My lord,
custody since 1/3/2024. Quantity is so much high. He has lost his one.
there are some paucity.
I am not considering anything.
Yes.
He has lost his one leg. He is unable
Because of the quantity, you can't lift so much.
to that respect.
How does it make difference?
My lord,
Despite you are handicapped, you are indulging in.
no, not indulging. He was taken lift in the truck. Driver is somebody else. I am one of the co. The vehicle was moving towards his residence, that is Bihar, my lord, to his native place. Taking that advantage.
But where are you doing? Here in Orissa? You are from
Odisha,
Bihar?
my lord.
You are from Samastipur.
Because
What were you
he is one of the advocate clerk. He has also engaged me some cases. I know him personally. And he has lost his one leg in Bihar.
On Bihar.
Bihar.
We are good enough.
His advocate telephoned me.
CD is there.
CD.
Call for CD. Call for.
Under the
32.
May I please, Lordship?
It will come on, my lord.
Let us see. Call for CD. Let us see. We don't have a case, but still, yes, because you said that.
Taking into quantity, I have rested myself.
We'll see if anything can be done. Yes.
May I please, Lordship?
32.
My lord, custody since 1/12/2023.
1/12?
2023.
Yes, 23.
23.
Yes.
Charge sheeted under section 498A, 304B, and 4 DP Act, your lordship.
Husband,
Husband, your lordship.
Yes.
What happened, your lordship?
Charge sheet
Charge sheet is submitted.
304B.
304B. 302 has been
302.
deleted. 302 has been deleted, your lordship. Just
Initial it was 302.
my lord.
Yes, okay. Yes. Charge sheet filed on
Charge sheet filed on 27/3/2024.
27/3.
Thereafter, I filed the appeal application.
Yes. Yes.
My lord,
death
what
is,
happened?
death is due to poisoning and its complications, however, no. It natural poisoning, routine visceral present. And
You just tell me what is the poison?
Rat killer, your lordship. Rat killer, your lordship.
Right.
I may be permitted.
She has taken herself.
She has taken herself, your lordship.
Show me that part.
My page number 30, your lordship.
30?
30.
30, yes.
30 from the top 8 number line.
30, 30.
30.
30. Okay. Come to that part.
My lord.
Read it.
Well, at the time of Mickey was
section 302, 201, 120B, 34 IPC.
CD? Yes. Yes.
The petitioner not named in the FIR. There is no eyewitness to the occurrence.
Custody.
Custody, my lord, since 23/11/2023.
23.
My lord. Yes. The petitioner not named in the FIR, no eyewitness to the occurrence. My lord, the dead body was found buried under the ground earth. Some villagers found it and intimated to the husband of the Sarpanch. Sarpanch reported the matter before the police and a FIR was registered. During investigation, police conducted CDR analysis and found that the deceased has frequent call with the one Prafulla Chandra Behera. Police apprehended Prafulla Chandra Behera. I am permitted to place the statement of Prafulla Chandra Behera while he was inside police custody, confessional before police, my lord.
He has confessed that Jai Chandra Singh is also there.
I am. Prafulla confessed before police that he has some enmity with the deceased because deceased has purchased a truck.
Whatever enmity is there.
Enmity with the deceased. He make a plan to kill the deceased. Accordingly, relevant person I am placing. तापर योजना मुताबक संजय बैग रे लुचाई रखिथिबा एक लुहा रड रे चित्तरंजन बेहरा द डिसीज्ड र पछपट मुंड को जोर रे बाड़े देबारु से तळे पड़ीगला तापर संजय सांगरे नैथिबा एक धारुआ कटर रे चित्तरंजन र बेक को 3-4 थर हानिला फल रे प्रचुर रक्तस्राव होई घटना स्थल रे चित्तरंजन मरीगला आसामी संजय बारिक कहिबारु रसमोहन सिंह अनदर अक्यूज्ड गाँ को जाई गोटे अखाबुरा और लुण नहीं आसिला एंड द प्रेजेंट पिटिशनर जयचंद्र ता घर को जाई गोटे कोदाल और शाबल नहीं आसिला
yes
at the instance of the present petitioner कोदाल शाबल was recovered that happened no other evidence
thereafter
there is the petitioner
thereafter the dead body was
first dead body was recovered
no dead body was destroyed.
No, dead body was buried under the earth.
Okay,
some villagers found that
putting salt and all.
Yes, my lord.
You ward member.
What is recovered? What is recovered?
My lord, particularly
Hujali and all.
Joy Chandra, my lord.
Joy Chandra.
Regarding this, Joy Chandra Singh was accompanied and participated with the main accused, my lord. And
no, not in the murder.
Not in murder, no, my lord. He has brought the
Sabula and
Sabula for the purpose of disposing of the body.
Yes.
But he has not participated in the main crime.
Yes, man. That is
the evidence. Even if you believe the disclosure statement of what is that?
Prafulla Chandra Behera.
He says that some who has given
Sanjay
has given the blow,
my lord,
and attack was by these people.
Prafulla also not
and Prafulla has also not done. But subsequent after the death, this accused has taken this
accused and at the time of assault, this petitioner was there.
No.
He was there.
He was there. Yes, man.
He was there.
He was there.
But he has not assaulted.
He has not assaulted. But he was there.
ମାଟି ଖୋଳିକି ପୋତିବାରେ ସାହାଯ୍ୟ କରିଥିଲା
Yes, 201.
201 is there.
Yes, ଜୟଚନ୍ଦ୍ର ସିଂହ ସିଜ୍ ହେଇଛି
He's entitled to be.
My lord,
He's entitled to bail. What do you say?
I am appealing for the father of the deceased, my lord.
What do you say?
My lord, ଜୟଚନ୍ଦ୍ର ପ୍ରେଜେଣ୍ଟ ପିଟିସନରେ ଜୟଚନ୍ଦ୍ର ପୋତିବାରେ ସାହାଯ୍ୟ କରିଥିଲା ଏବଂ ତା ଘରୁ କୋଦାଳ ଶାବଳ ଦେଖେଇବାରେ ପୁଲିସ ତା ଠାରୁ ଜବତ କଲେ।
You are not opposing.
My lord.
Not opposing.
And this much, mind.
This was the material.
This much.
If you inside the jail, if you can manage him, if you come outside, what happens? Just imagine. Petition is accused in so and so. The petitioner is primarily accused in the for the primarily the accusation against the petitioner is primarily for the disposing of the dead body of the deceased. She has been entangled in the present case on the basis of the disclosure statement of the principal accused,
Prafulla Chandra Behera.
Prafulla Kumar
Behera.
Prafulla Kumar Behera. The disclosure
Prafulla
statement-
Chandra Behera.
Chandra Behera. Disclosure statement of the co-accused Prafulla Chandra Behera was read out in the court. It reveals from the statement that it is Sanjay Kumar in presence of
Present petitioner.
it is the Sanjay Kumar Singh, Sanjay
Sanjay Kumar Barik.
Sanjay Kumar Barik, who has given the fatal blow to the deceased in presence of the Prafulla as well as the present petitioner.
Petitioner and Joy Chandra Singh.
Death of,
And another Joy Chandra Singh.
and Joy Chandra. Prafulla,
So-
Joy Chandra Singh
And present petitioner.
and the present petitioner. Present petitioner. After the after killing the dead body of the deceased was being disposed of, and in that act the petitioner has
Participated.
Next one. Petitioner is in custody since 23/11/2020. Since there is no overtake attributed to the petitioner insofar as commission of the prime offense is concerned, and the only allegation against him is regarding the disposing of the dead body after the commission of after killing the deceased. I am going to enlarge the bail accordingly. The petitioner is going to be subject to all conditions. Yes.
May I please your lordship?
Yes.
Offense under sir 20B 2C indicates act by law.
Yes.
And petitioner arrested on 27/2/2024.
27/2/2024. Yes.
And the charge sheet submitted 23/8/24 act, my lord. And quantity of ganja is 29 kilo 900 gram 30 piece. And 2% and
Both are from Bihar.
At the Sambalpur.
Quantity is less, 30, but both are from.
Khatraj station. Entrance.
All right, but how will you ensure the presence?
My lord, any stringent condition may be fixed. Our relation what a bellor ru. Sambalpur present pillars.
Apart from that, you lordship may impose some cost because impose some cost, my lord. Apart from this,
Cost for what?
my lord, cost means some amount may be.
No, I think every month, the last Sunday, he has to appear in the before IH. First condition.
My lord.
Second condition is local surety.
Local surety, yes.
Local surety and a relative. Write down, huh? Local surety and relative, because they are belongs to
Bihar
Bihar.
jo Champaran
And
PS.
every month appear before the IIT on Sunday, huh? Sunday. And subject to verification. 29 kilo. 29 kilo?
49
kilo 900.
Custody since 27
to 24.
Yes, next.
I prefer on behalf of Mr. Das, adjournment.
Request adjourn.
37 already acquitted, man.
Acquitted. Disposed of, huh?
38, my lord, 376, 6 POSCO. And
Yes.
and the victim stated custody since, my lord, 6/2/2024.
Okay. Yes.
And victim stated in her
Charge sheet filed.
yes.
Charge sheet submitted on 3/4/24.
Okay.
ବୟାନ ଦଉଛି ଗତ 23 ତାରିଖ ରାତିରେ 164 ଷ୍ଟେଟମେଣ୍ଟ 23 ତାରିଖ ରାତିରେ ସନ୍ଧ୍ୟା 7ଟା ବେଳକୁ ଲିଟୁ ସୋରେନ ଆମ ଘରକୁ ଆସି ତାଙ୍କ ସହିତ ଦୋକାନକୁ ନେଲେ ସେଠାରୁ ତାଙ୍କ ସହିତ ଯିବା ପାଇଁ କହିଲେ ମୁଁ ମନା କଲି ଯିବି ନାହିଁ ବୋଲି କହିଲାରୁ ମତେ ବମ୍ବେ ନେଇଗଲେ ସେଠାରେ ଆମେ ସ୍ୱାମୀ ସ୍ତ୍ରୀର ସମ୍ପର୍କରେ ରଖିଛୁ ଆମେ ବାହା ହୋଇ ନାହୁଁ
Service, what is the position?
Service notice has been sufficient. Kebe notice sufficient ko na.
There is nothing on record, that's the problem.
On 21/6/2024, notice was made sufficient.
Nothing is there. Nothing.
Notice sufficient.
But I have to go by my record.
Yes, yes.
There is nothing. There is no verified next week. Huh? Verified. Likho. He says that the order was passed. Order is not there. There is no endorsement that you have filed.
Yes, yes. I have filed the requisites, my lord.
Requisites. That is also there is no official noting. When you file
extra copy, I have
official
given
notice. Defect pointed out by SR is removed. What is there? Why it is not?
It updated hai na to aija.
Service position.
Nothing is there.
Upload hai na to. It achi aija. The order I got.
I got that order.
Yes.
It's not uploaded. That's the problem. You
Order is
verified.
there.
List it on Monday. List it on Monday. Verify, upload everything. And the report also. Recent report regarding the service. Yes.
39.
Yes.
My lord, the petitioner is in custody since 25/2/2024.
25?
February
25/2/24.
Yes.
Charge sheet submitted for commission offence under section 376(2)(n), 323, 506, 66E and 67A of IT Act.
Yes.
The victim is the sister-in-law of the petitioner, age around 23 years. The victim was staying in the house of the present petitioner when the wife of the petitioner was pregnant. The victim alleged that during that time, the present petitioner kept physical relationship with her, and showing the photograph of the victim, force her to keep.
He is the brother-in-law of the victim.
Vinay.
And the
Dhoni
164 statement.
pregnant thila, victim tanka ghare rohte to help. Thereafter, after many days, victim alleged that je sei samare mor kichi photo rakhi.
Jan 2024.
Yes.
Now, I'd like to place a fact that the petitioner is charged with the murder of his own son, mothers, in this case. The deceased, the petitioner is charged for the murder of his own son. The deceased was the son of the petitioner, mothers. Now, what the prosecution story reveals, mothers? The prosecution story says that in the intervening night of 8 Jan 2024, 9 Jan 2024, in between 1:30 a.m. to 2 a.m., the wife of the informant received a telephonic call from the wife of the petitioner. The wife of the informant is the brother of the petitioner, mothers. So on receiving the call, it was informed that Nandu has been killed. Nandu is the deceased mother.
How can the wife will be the brother?
Wife, the informant is the brother of the petitioner.
Oh,
my
you,
lords.
you tell like that, yes.
Yes.
Ah.
So in the telephone, through telephone, it was informed that the deceased has been killed.
You tell me the evidence. What are the evidence against
Yes. Now, Your Honor, my lords,
you? Yes.
the prosecution material is sufficient enough to obliterate the petitioner from the charge. By the time the petitioner was arrested, my lords, 18 number of witnesses were examined. And none of the witnesses implicated this petitioner or anyone, as there was no eyewitness to this occurrence. Now, how the petitioner was arrested, the question arises, my lords. Now, I would like to draw your lordship attention to the 161 statement of the wife of the petitioner and daughter of the petitioner. On the basis of their 161 statement, the petitioner was arrested. Now, their 161 statement is recorded on 13th of January itself, my lords, and it is annexed under annexure. It is under page number
1 minute.
Page number 52 and 53, my lords.
This is the son of the present.
In the bail matter, you need not argue for such a long time. You tell me the crux of the matter. The very fact that so many things are involved, you are not entitled to bail.
I'm sorry.
Come to the point and tell me.
My lords,
Yes.
my lords.
1
minute. Yes.
This is the son of the present petitioner. He was a drunkard. He has assaulted his father, mother, sister, all. Then, my lord, to rescue the wife of the present petitioner, he protests the deceased and assaulted by means of a spade. That the wife or the mother of the deceased and the wife of the present petitioner and sister of the deceased, they were the eyewitnesses. In 164 statement, they have categorically stated that my father has assaulted by means of spade.
Because he might be a disturbance in the family. He was attacking you to save the father.
Yes, madam. And there are deposition.
And there are 164 statement.
161 statement, but they were examined before the court below. That eyewitnesses. They are in the deposition copy, my lord. They were torn hostile. They have said they are the wife and the sister.
Obviously.
That the present petitioner, though, is the.
They have not supported the prosecution. None of the witnesses.
Only eyewitness, mother and sister, they have said the present petitioner, they have torn hostile.
Just because they have done outside means that doesn't mean they are supporting me, my lords. They have submitted truth before the honorable court during the time of the deposition. In flag
I think you are mixed up with the other side.
my lords, they are blowing hot and cold at the same time.
Prosecutor is trying to help you out. Please hold on.
My lords.
These are the two eyewitnesses.
My lord, two mother, one is Balarani Banerjee, another is Trishna Krishna.
Allegation against the petitioner. There are two eyewitnesses to the occurrence. The first eyewitness, both of the eyewitnesses have already been examined by the prosecution as PW2 and PW4. Both of them have not supported the prosecution. The allegation against the petitioner, the petitioner is the father of the deceased. It appears that the deceased has been harassing the entire family. And on the fateful day, he was completely drunk and started picking up quarrel with the family member, and started beating his own wife. To save the wife of the deceased, the
wife of the present petitioner,
wife of the present petitioner, the present petitioner, who is the mother of the deceased. Mother of the deceased.
Mother of the deceased.
And petitioner is the mother. He is the
son of the petitioner.
Son of the petitioner.
Yes.
Son of the petitioner is known as that. Why he assaulted the wife of the present petitioner. Present petitioner mother of the deceased.
Mother of the deceased. That's what mother of the deceased. The present petitioner. What a single blow case.
Single
gave a blow
by spare
gave in the fit of rage, the petitioner, who is the father of the deceased, had given a blow by means of a act, by means of the petitioner succumbed to the the victim succumbed to the injury, since both the only two eyewitnesses to the occurrence have not supported the case, and the petitioner is in custody since 13/1/2024, I'm inclined to enlarge the petition on bail according to the enlarged on bail. Yes.
41. This is also private defense, right to private defense.
Huh?
Right to private defense. This
Right
type
to
of sound
private.
my lord.
I know.
Because the sister has made some allegation against the deceased.
I know he must be a disturbed child. Yes.
My lord, petitioner has been languishing from jail custody since 11/4/2024. 11/4/2024.
390 to 25 arms, though CD is not there, but some of the articles and which.
Call for CD.
And he has 10 numbers of antecedent that he filed the.
You file an affidavit stating the detail of antecedent and meanwhile CD called. Fine, huh? Yes.
42.
Yes.
Yes, my lord. The deceased and the petitioner were in law, my lord, since last 2 years, my lord.
Yes.
The deceased was insisting the petitioner for marriage. And my lord, while the petitioner denied the case because she had 2 elder sisters, my lord, they are yet to be married, my lord. The petitioner refused. And out of a quarrel, my lord.
Custody since?
Custody since, my lord. 30/12. 30/12/23, my lord. Yes, of 306, my lord.
12? 23?
23, my lord.
Yes. It's 302.
302 turned to 306, my lord.
Okay.
306 charges.
Yes. Yes.
But on the fateful day, my lord, the deceased has come to the house of the petitioner that why you are not marrying me. The petitioner refused because I have 2 elder sisters that are yet to marry, my lord. And she had come with the petrol jerkin, the deceased, and set her ablaze in the house of the petitioner, my lord.
He herself
Yes.
told me that.
My lord, that is the dispute. That some
He herself did it or you did?
No, that is
the dispute. Who has poured the
That part only you show me.
My lord, the neighbors, they have stated.
Hmm.
Some of the neighbors.
Sudarshan Singh katham gote kaul sunun khali gote one line.
No, then why have you dropped 302? then?
Exactly, my lord.
My lord.
Why have you dropped 302? Then the prosecution, the investigating agency believes that it is 306.
Yes.
He fought herself.
Apparently, my lord, that is 302. Because why a person who is that a lady, she will come to the petitioner as with a petrol jerkin.
To threaten to marry me,
No,
otherwise.
Yes, that is the fact.
He was with the present petitioner. There was a relationship. She compelled the present petitioner to marry. Then, my lord, the allegation is that they pour the petrol to the deceased. And born injuries, my lord, is 60 to 65.
You leave that part. Then you should have filed charge sheet of
302. Yes, yes.
That is the matter. That is the latches of the prosecution. Because some of the witnesses, that is admitted that he was present in the petitioner house. It is admitted that
accused are acquitted because of latches of prosecution only.
But case I am saying
and my
that
lord,
one
100
statement-
ml only.
And 90% conviction is because of the defense lawyer. If
One
there will
statement,
be
my
no
lord,
defense lawyer, you will see they will be acquitted.
one statement I reading, my
Defense
lord.
lawyer only invite
One statement I am
problem
saying,
for by putting questions unnecessary.
ଏହା ପରେ ହଠାତ୍ ମମତା ପେଟ୍ରୋଲ ଢାଳି ନିଜକୁ ନିଜ ଉପରେ ନିଆଁ ଲଗେଇଦେଲେ.
Who has said that?
That Sudarshan Singh, that independent witness, my lord.
Independent.
Yes.
Yes. Do you have anything?
My lord, that is some of the witnesses. My lord, I am reading.
Who has
what
said that?
Dhananjay Singh, my lord, I am reading. Laborer, my lord, one laborer. That
yes.
The alleged offense is under section 20B2C and the quantity is 25 kgs, 900 grams.
25 kg, 900.
25?
25 kgs, 900 grams.
Ganja.
Ganja.
And subject to
verification.
No antecedent.
Subject to verification.
May I pray, Lordship, sentence? Item 47 is co-accused.
Co-accused. 47 also same. Subject to verification.
Lordships. Oblige.
Yes.
44.
My lord, BLPL number 5381/2024 is wrongly tagged with the other.
No, that is a separate matter. That is another matter.
54?
That is
5938.
5938.
5938 alga kar diya. D tag and list.
That matter may be withdrawn, my lord.
Withdraw.
Withdraw.
Withdraw. Yes. Withdraw. 5938.
5938. Connected matter.
Yes. Rest of the matter I told you to prepare.
Rest of the matter, madam.
Prepared.
Yes, sir.
ତା ଦେହରେ ଗୋଟେ ଆଉ ଆଡ୍ ହେଇଯିବ ସେଇଟା ହଉଛି କେତେ ନେବ?
Item number 77.
ଏଇ ଯୋଉ କେସ୍ ଗୁଡାକ ସିରିଏଲ ଅଛି ତା ଦେହରେ 77 ଟା ଆଧେ ରହିବା କଥା।
77. Have you seen it? 77 also.
77. If connected matter, my friend.
Same.
Same thing.
So I'll take it at Monday. 77. Chart for 77. Monday. Prepare a chart and give me.
Because 379, 380 offense. And some of the, he was remanded in this case. First, he was arrested in a PS case number 25 of 24.
Peculiarly, first case is the last one, and all the cases are the earlier case. In last case, in which I was released on bail, some articles were seized from my godown. Thereafter, what they did, the same seizure list was used in the other cases, and I was remanded.
Same seizure list.
Only one seizure list. And in that case, I was released by the bail by this honorable court. And using that seizure list, all other cases I was remanded.
In that case, one seizure was there. One case, one.
And
Because they are stolen the accessories of that articles of the temple. Some of the articles are seized from the present petitioner in that connected matter.
In the first.
সেটা ফার্স্ট কেস নয়, সেটা হচ্ছে শেষ কেস।
Last case.
ତା ଦେହରେ ସିଜର ହେଲା, ଏଗୁଡାକ ପଡିଥିଲା ସେମିତି ଏଫଆଇଆର ଦେଖିଦେଲେ ଗୋଟେ ସିଜର ହେଇଗଲା, ସେଇଆକୁ ମାଗି ଦେଇକିରି।
That case he was arrested.
And how many cases?
My lord, nine antecedent is there against present petitioner.
9 antecedents subsequently.
No, that was an earlier case, my lord.
Earlier cases were pending, you were taken remand.
In this case, it was remanded.
You could not solve the cases, you found someone and
Those some articles were seized.
one, and you using that seizure list everywhere.
Yes, you are used.
I'll take it tomorrow then. 77 also, huh? Give a chart.
From 2017, the allegation is that the antecedent is from 2017.
2007, why have you not arrested?
2017, man.
17.
My lord, 2017.
Why have you not arrested? 2017, you didn't do anything. You arrested in one case. Now all the old cases thrash open.
Not seen with the condition, but 387, 379, 380.
All those.
ଗୋଟାଏ କେସ୍ ରେ ଟିକେ ସିଟି ନମ୍ବର
These are the different FIRs.
Different affairs.
different.
Lordship, I filed a chart.
SK7. Give the chart.
Already filed.
I would.
All the cases are like that, huh? In which case you were taken into remand?
Taken in my lord, Khunta PS case number 25.
First 1 and 2 released on bail by this honorable court.
First 1 and 2.
1 and 2.
Tell me what.
I will rest
First-
5.
You were arrested in which case, first of all?
That is my lord in Khunta PS case number 25 of 24.
ଏକ ନମ୍ବର ଯୋଉଟା ଅଛି।
No, Chandipur PS.
So I can order Chandipur, sir.
Khunta, where is that Khunta?
ଏକ ନମ୍ବରଟା କୋଉଟା ଅଛି?
Khunta PS is not there.
Okay.
So I'll request, it was a small amount, I put an argument on that. It will be better, it will taken up on
Let
Monday.
it be on Monday.
I am not on merit.
I
Let me-
understand. But see,
I am on a very limited question. The maintenance.
I know, I understand that, but
Yes. Well,
I
I'll
thought-
adjust. But the thing is that this is happening as a day-to-day affair.
all right. I have
But-
already reserved judgment. Sir.
But-
If, no problem by that
But-
time, Monday.
Much obliged. Much obliged.
Yes. 44, huh? Now you tell me, so give me that chart.
Yes, sir.
Added these two cases. Huh? Is there, na?
My lord, the list which he has given, that is the
40,
case.
44, huh?
Yes, sir. 44, my.
Yes.
The list which he has given, that is the cases in which he was remanded. I think that he has antecedent, more than antecedent, 7 numbers, more than he has given that.
9 cases.
Again?
Total 9 cases.
Total 9 cases. In some of the cases where he has mentioned that it is not in the antecedent list, some of the cases there is the antecedent. Perhaps there, if you will calculate this chart, then there is more antecedent than 9.
In which case you were taken into custody?
Yes, that one I have given also. Lordship in
First case.
Lordship in Chandipur PS case number 46 of 2020.
You were taken in custody.
Yes.
What is the name of, what is the, in this case, which is the FIR?
Lordship?
Kaptipoda PS case. This is Kaptipoda case.
This is Kaptipoda, yes.
Yes, sir.
And what about the second one?
But my lord, in my record, where the remand was made in this case, first he was apprehended in Khunta PS 25 of 24.
Bodosai PS case.
That Khunta PS he has not mentioned, but in the
If you with clarity, if you give the fact, then only I can give
yes,
this.
yes, but as per our record, my lord, this is Khunta PS. But he's saying that it is Chandipur PS. Well, can you see for a moment, my lord.
How can I give the, how can I pass the order? You have, unless you tell me the real facts.
Remand application, my lord. Remand application, my lord, can you see? In that case, I have marked on the red color. He was apprehended on
Punta PS case. Where is Punta PS case?
my lord, I have marked in a red color.
PS case number is not there.
My lord, Punta PS case number, red color, my lord.
It is only Punta PS. Number is not there.
Lordship, he was
No,
arrested.
24 by 25 by 24.
Lordship, he was arrested in Chandipur PS case number 46 of 24. Is the order I have given. Lordship.
He is saying something else.
He is saying, but our record.
Keep it on Monday, be clear about it. I can't. He is something, remand order is saying something.
Remand order is my
Huh.
Punta PS.
Lordship, but I have the order.
But no, but nothing. You have to see the remand order also.
PS case
You have to sure about it. I have to give dictation.
Lordship, I am sure that he was arrested in this case.
Then what will I do with this remand order? In the remand order, it is written something else. What would I do? You have to be sure about. See, there are how many cases here?
Lordship, all total 5 cases.
5 cases here.
Yes, sir.
All 5 different FIRs.
Yes,
Different
different
FIR.
FIR. So therefore, which case you are taken into custody, and where he was supposed to have.
And on his submission, Lordship may pass order that on the submission of the present petitioner, he was remanded in PS case number so and so.
And on the confession, all these cases were.
Right.
Yes, sir.
That's what it is.
Yes,
Right?
sir.
Then I'll ignore that.
Yes, my lord.
Right now. See, 1, 2, 3, 4.
Lordship, another is item number 74.
4 and 5. There are 5 cases. Okay, 5 cases, 5 different FIR. Okay, right. Petitioner is accused, allegation against the petitioner. Mr. Soro Mahapatra, senior counsel, submits that the petitioner was in fact apprehended in Chandipur PS case number 46 of 2024. 2024. In the when during his custody in that during his custody in the same case, the petitioner is stated to have disclosed regarding his involvement in the instant FIR. Subsequently, he was taken on remand. Remand on which is this case? First case is
5707. So in this case, I was taken on remand.
This is Katipoda PS case number 27. When taken on remand on 17/5/2024. 24. The occurrence alleged to have taken place on 16/1/2020. In the instant. Next part. Insofar as the Chandipur PS case number 46 of 2024 is concerned, in which the petitioner was arrested, this court, while allowing PLAPL number 4544 of 2024, while order dated 15/5/2024, already enlarged. The petitioner is in custody since 17/5/2004 regarding to the nature of acquisition and the fact that the petitioner has been enlarged on bail in the case in which he was arrested. I am inclined to enlarge the petitioner on bail in the present case as well. And likewise, you take the chart likewise.
Lordship, in one case, one city number has been wrongly.
I will not correct it. Wrongly means wrongly. You have no this thing. Which case?
Lordship, that is really first one. 5707 in city case number.
133 of 27.
Whatever city case you take it here. Okay. I can't reach time. Yes. Next. 45.
77.
44 and 77. You question would have been 7. Yes.
45. This is a bail under section 457 380 IPC, my lord. And the fact of the case is that the petitioner broken the gate of the Mahadev temple, entered into the Mahadev temple and taken away the Gora, Pitala and all the temple articles.
Custody since?
My lord.
Custody,
my lord. 7/5/24. My lord has the honorable court has granted bail in same case, my lord.
Same accused.
My lord.
How many cases you have?
My lord.
26.
26 number cases. 26 cases.
No, my lord. Not 26, my lord.
15.
How many cases?
4 to 5 cases, my lord.
He says 26 cases.
My lord, kindly see. My lord, kindly see in the chat sheet.
File an affidavit. Learned counsel for the petitioner is time to file an affidavit detailing the antecedents, stage of the cases, etc., etc. 46. There is 44 is doing the
And kitna it is?
6 months. 26.
26.
46. Mayor, please do not assume.
Madam Arjun.
Arjun, he has to file an affidavit regarding interim. He says 4, you say 26.
26. When the charge sheet matter elaborately discussed in which cases he was involved.
44 minor has granted, but same case minor.
That's right, but I need to know how many cases
Minor,
are
minor,
there. So therefore, you file an affidavit giving the chart. Yes.
May I please the lordship, my lord? Petitioner is custody since 13/24/24, my lord.
For the informant, well,
20?
46.
24/20 20/4/2024.
Yes. Yes.
The 160% recorded not supported the prosecution case, my lord. May I read, my?
Yes, 24 you are uncreated. What?
ମୁଁ ଗୋଟେ ପିଲା ମଳୟକୁ ଭଲ ପାଉଥିଲି ଗତ 30/3/24 ମୁଁ ତା ସହ ରାଜକୋଟ ପଳେଇଗଲି ଆମେ ଦୁଇ ସ୍ୱାମୀ ସ୍ତ୍ରୀ ଭଳି ରହିଥିଲୁ ମୋ ବାପା କେସ୍ ଦେଇଥିଲେ ପୋଲିସ ସେଠୁ ମତେ ଆଣିଲା ସେ ମତେ ଜୋର ଜବରଦସ୍ତି ନେଇ ନଥିଲା
What is the FIR number?
Well, that is 77 of 20. Norla PS case number 77 of
FIR is not filed yet. Therefore,
given, my lord. Earlier filed, but I am given today, my lord.
everything you keep it with you.
No,
It's not
earlier-
filed in the petition.
Earlier filed, my lord.
Not filed.
Yes. Along with the bail application, not filed.
Why have you not filed?
Sir,
If
not-
it was there with you,
No, my lord, it was not with me. Letter came to me, my lord. Sorry, my
anyway,
lord.
164 read.
Yes.
ମାନେ 164 ମୁଁ ଗୋଟେ ପିଲା ମଳୟକୁ ଭଲ ପାଉ ପ୍ରେଜେଣ୍ଟ ପିଟିସନର
ମଳୟ।
30/4/24 ମୁଁ ତା ସହ ରାଜକୋଟ ପଳେଇଲି ଆମେ ଦୁହେଁ ସ୍ୱାମୀ ସ୍ତ୍ରୀ ଭଳି ରହିଥିଲୁ ମୋ ବାପା କେସ୍ ଦେଇଥିଲେ ପୋଲିସ ସେଠୁ ମତେ ଆଣିଲା ସେ ମତେ ଜୋର ଜବରଦସ୍ତି
What is the age?
70.
is at that time my lord 15 years.
Now she is 17 years.
ନା ମାନେ ଏଇ ଟାଇମ୍ ରେ ହିଁ ମାନେ it is about 24, my lord.
Read it, read it. ଜବରଦସ୍ତ କଲା।
ମାନେ 30/3/24 ମୁଁ ତା ସହ ରାଜକୋଟ ପଳେଇଥିଲି ଆମେ ଦୁହେଁ ସ୍ୱାମୀ ସ୍ତ୍ରୀ ଭଳି ରହିଥିଲୁ ମୋ ବାପା କେସ୍ ଦେଇଥିଲେ ପୋଲିସ ସେଠୁ ମତେ ଆଣିଲା ସେ ମତେ ଜୋର ଜବରଦସ୍ତି ନେଇ ନଥିଲା ମୁଁ ମୋ ଇଚ୍ଛାରେ ଯାଇଥିଲି।
My lord, subsequently, earlier in FIR 363 was, but subsequently 376(2) and 366 was added. my
She
lord.
says something else.
My lord, she
And
was-
this boy is also 24 years
and
old.
she is the, how, you will also very well know that she is victimized, my lord, and she was under mental.
He doesn't say that she is victimized. You are saying.
No, no, my lord, the thing is that she was been forcefully taken, my lord. That is,
But she says something else, madam.
as your lordship decides.
He says something and they see the age of this boy. He is also 24. They are all young people.
And moreover,
Also denied for medical
exemption.
I don't petitioner is accused in so allegation as it excludes from the statement of the victim who stated to me 16 years of age has been recorded on 64 years. He has stated that what he has stated, read it out.
that I am voluntarily
Read the sentence.
ମୁଁ ଗୋଟେ ପିଲା ମଳୟକୁ ଭଲ ପାଉଥିଲି
She stated that she has been in relationship with the petitioner and
30/3/24 ମୁଁ ତାହା ସହ ରାଜକୋଟ ପଳେଇଥିଲି
on 30/3/24 she had gone with the petitioner to Rajkot and they stayed there.
And we are staying as husband and wife.
husband. She also specifically stated that the petitioner has not
Forcefully taken me?
taken
on my own police
taken. When she also refused to
For medical
participate in the medical examination. Petitioner is in custody since 20th 48/4/20 and he is a 24-year-old boy and regard being head to the nature of the petition either for the petitioner and period of custody granted. Yes, next.
My lord, though 376(3) is there, notice was served and informant was appeared, that may be repeated.
Notice was served on the opposite party. Number 2, the informant so and so entered appearance and opposed the bail. Yes.
Obliged.
48.
May it please your lordship, my lords.
Yes, sir.
That's both the petitioners, my lords, are in custody since 9th of March 2024. That's the 9th March 2024, my lords.
Yes.
The FIR was lodged under section 498A, 302 and 34 of the IPC. During the pendency of the present bail application, my lords, in the meantime, charge sheet has already been submitted. In the charge sheet, my lords, 302 is not there anymore. It is 306, my lords.
Then you approach the trial court.
No, my
Now
lords,
charge
your lords
sheet
is
is
my-
filed.
But actually, charge sheet was submitted on 6/5/24.
6/5/24.
24.
Yes.
Rejection order is
When you the 302 was there, you approach the court. Rejected the bill.
rejection order is on 10/5/24.
Right now.
10/5/24.
But at that time, it was not placed before the presiding
it was
officer.
not placed, my lord.
Because in the rejection order, it was stated that the offense is 302,490.
That's right. Therefore,
No, my lord, may
It is-
kindly see, there is material, the IO did
I
not submit the
understand,
report.
but go to the court of first
Yes, that is
instance. Right on. Petitioner is agreed by the order dated 14/5/2024, whereby his bail plea has been rejected. Initially, the FIR was registered against the petitioner for alleged offence under section 498A 302/34 IPC. However, after investigation, charge sheet has been filed on 6/5/2024. In the charge sheet, the allegation of 302 IPC has been dropped, and
306 was added.
498, 34 and 306 of that.
306 has been implicated. In the changing, therefore, in the changing circumstances, petitioner seeks to renew his bail plea before the court of first instance. If such bail application is moved, the trial courts shall consider the same within 15 days of filing the same on the basis of the material form part of the charge sheet. Yes, sir.
49.
May I please, Your Honor? My lord, case offence under Sir 360, 376AB. Charge sheet already submitted. My name not in the FIR, my lord. Subsequently, my name entangled in this case, my lord.
Yes.
My lord, I am already jail custody since 12 October 2023.
12/10.
My lord.
Yes.
My lord, I'm just.
What is the role ascribed to you?
My lord, no role. My lord, my name not in the FIR. Firstly, my lord, just I am reading the FIR.
Read the charge sheet.
I'm reading the 164 statement, who is the minor girl, 11 years.
12.
376 AB is there, and 67 POSCO is there. 366 also there. I'm reading that petitioner's age is 36 years.
I know, I've seen it.
And my lord, I'm reading that question, my lord. ଯେ ମୋ ଭାଇ ମତେ ବାଡେଇବାରୁ ମୁଁ ସକାଳ 5ଟା ବେଳେ ଘରୁ ପଳେଇ ଆସିଥିଲି। ବାଟରେ ଗୋଟେ ଚିହ୍ନା ପିଲା ଯାହାର ନାଁ ଚିଣ୍ଟୁ ମୋର ଦେଖାହେଲା। ତାପରେ ସେ ମତେ ଡାକିଲା, ମୁଁ ତାଙ୍କ ସହ ଗଲି। ତାପରେ ମତେ ବେହୋସ କରି ଦେଇଥିବାରୁ ମୁଁ କିଛି ଜାଣିପାରିଲି ନାହିଁ। ତାପରେ ସେ ଆଉ ତାର 4 ସାଙ୍ଗ ମତେ ଗୋଟେ ଘରକୁ ନେଲେ, ନେଇ ରଖିଲେ। ତାପରେ ସେମାନେ ଚିଣ୍ଟୁ ହାତରୁ ଖାଇବା ପଠାଇ ଦେଇଥିଲେ। ଯେତେବେଳେ ଚିଣ୍ଟୁ ମତେ ଖରାପ ଖାଇବା ଆଣି ଦିଏ, ତାପରେ ସେମାନେ କହିଲେ ସେ ଖାଇଲେ କେତେ ନ ଖାଇଲେ କେତେ।
Committed sexual assaults against the will of the minor child, and petitioner is 36 years old. And regarding the nature of accusation and the age of the petitioner, not inclined to understand. Next. 50. Yes, sir.
May I please, Your Lordship?
Yes.
And
My
here
lord,
also one thing, that notice was served that 3763 is there.
I am rejecting it. Notice was sufficiently served.
Notice was served to the victim.
Non-appeal.
My lord, petitioner is inside custody since 4/3/2024, my lord. And the fact of the case. 4/3/2024.
Yes.
And fact of the case is, the informant took the victim to the hospital when she was sick. In the hospital, she came to know that her daughter was pregnant. When she asked about the daughter,
Medical examination statement.
Medical, she was pregnant. Medical examination, my lord, she was pregnant.
Yes.
And victim age is 15 years. Petitioner age is, my lord, 23
30.
years, is a married person.
23 years.
And a married person.
You are married.
And the her 164 statements, she has categorically described.
What is the age of the girl?
15 years.
15 years.
age of the petitioner is, my lord, 23 years, and that
But you are married. You are married.
He
His
left
age
her.
is 23 years.
He is married.
married person.
His wife left her, my lord, since last 2 years.
Therefore, you can exploit anyone, right? This is exploitation. Petitioner rejecting the report, allegation in the petitioner report. Statement of court, the victim who is stated to be 15 years has been recorded under section 164 CRPG. Perusal of the same reveals that the petitioner, who is a married man, exploited the minor girl, regarding it to the nature of acquisition and age of the victim girl, and the fact that the petitioner is a married man. I'm not entitled to enlarge the bail. Accordingly, the same is released. Yes.
And my lord, notice was served on 27/7/24 to the informer.
Notice was served on 27?
27/7/24.
24 on the
My-
party number 2 wishing. However,
My lord, one submission, please. My lord, that victim girl gave birth a son, my lord. In the meantime,
She was at that time she was pregnant.
at the time she was pregnant, he gave birth a child, and the petitioner is willing to marry her.
and you
Only
move
who
application to try to learn counsel for the petitioner. The state submits that since the minor girl has already
Gave birth a son.
given a birth of
Yes.
son, and he is willing to marry her, and therefore he seeks indulgence of this court. The petitioner is given liberty to move appropriate application for the court below. In that if such application is moved,
That marriage may not be reflected because he was a married person.
Yes.
How he will
Yes,
marry
yes,
again to
he
the?
has said that he is separated.
His
No, no.
wife
Once
already
he was
left her.
married, that present petitioner is married person. How he will marry again to the victim?
Exclude the
That
possibility
may
of
not
settlement.
be-
Marriage जाकर करते हो, exclude the possibility of settlement. The marriage is not correct. If you want to marry, exclude the possibility of settlement. Yes.
May I please roll on? The custody in 10/5/2024 below commercial quantity, no criminal antecedent.
What is the recovery?
126 gram of brown sugar.
126 gram.
Custody since 10/5/2024.
Brown sugar.
10/5.
2024. No criminal antecedent.
CD is there?
No, not sir.
CD is not there. Call for CD in 1 week up.
My lord,
Grant the bail without CD you can't be.
Lordship, may kindly fix a date, my lord.
Date?
Prior to vacation.
After 1 week, call for CD. Yes. 52.
It also, I has asked time, lordship.
52.
Yes. 25 kg ganja.
CD is not there. After 1 week, CD call. 53.
53, my lord, initially 498 and 376. And thereafter charge sheet submitted 376, 506.
498A.
Again.
Admin what?
See the 164 statement रे कहूची जे पढ़ दूचे के तो 164 रे कहूची मु बयान देउची सुनील अर्जुन आम गाँ पांडरीगुड़ार पिला ताकू छुआ बेलू जानिची गत 3 मास तले मु गाँ रे मो बड़ माँ घर थिली सेतेबेले सुनील मते भले रखिबो भले
The allegation is pretty clear. The statement of the victim prosecutory was recorded under 164 CRPG. He has stated that she has been she has been in relationship with the petitioner. Petitioner has taken her to
his house.
His house, promising for a customary marriage, bracket invited Udilia, customary marriage. They remain, they stayed as wife and husband for quite some time. However, the petitioner subsequently wriggled out of the promises made by him.
ना ता माँ बापा कौन टिकी ताको गाली करले बोली से तांको रू पड़े
तापरे बड़े बड़ी कले बोली से जाइछि.
And
Now she is with her parents house.
she further stated that her parents did not agree with the alliance, therefore he had to go back and file the
Yes.
present case. Petitioner is in custody since 10/5/2024.
21/5.
Huh?
21/5/2024.
21/5/2024 regarding it to the nature of petition, period of custody, and the age of the petitioner being 20 years. 20 years, I am inclined to enlarge the petition.
Petitioner parents did not allow her, or that only.
Yeah, I'll tell you.
Yes.
I'll tell you. I know this area, and every Dasera night.
But recording is there that herself is
and
going
this
to the
Udriya
pictures.
marriage takes place, and next Dasara next day there will be some murder, and both wife and husband go, and they search for alliance. Sometimes what happens? The wife gets the alliance, husband doesn't get the alliance. Then there will be a fight in the village, and one murder will take place.
No,
It will
right.
be routine thing.
Not say I want only then in writing it is there that she is with her parents, not that they left her.
ଝିଅର
that
ବାପା
is
ମା
the
ଯୋଉ
word
ଲେଖିଲେ
there.
ସେ କହୁଛନ୍ତି ପୁଅର ବାପା
Poor
ମା ଗାଳି
Papa
କଲେ
Krishna.
ବୋଲି
For that only, that is the writing should be. Yes.
I don't know.
The parents of the petitioner.
Parents of the petitioner did
Petitioner.
not agree. Did not agree for the alliance. Hence, she had to go back to her parents.
Yes.
Yes.
My lord, may I please your lordship
Yes, sir.
that offense under section 307 IPC and other also.
Custody scenes?
Informant and the accused persons are neighbor. On the allegation that on 20th April night 2024.
You are a custody since you tell me.
Since 30/5/2024.
30/5/24, yeah?
2024.
Injured,
30/5/2024.
injured cause by
It is simple injury, one is grievous in nature.
grievous where? Which part of the body?
Every part, it is shoulder and hand.
What is the weapon of offense?
Lathi.
Lathi. Single blow. Single blow. Not in the vital part. Not in the vital part.
ଗୋଟେ କାନ୍ଧରେ ଲାଗିଛି.
Vital part. Kind of petition. From the evidence collected by the police, it reveals that the petitioner has assaulted the victim by way of lathi.
Lathi and khonda. Sword also.
Sword. Sword by him. Who was holding sword?
Petitioner.
That's what I'm asking.
His son and wife are entangled in the affair. But
How many accused persons are there?
Here is one.
Wife and petitioner are related.
Here
to
also one the
How many
Raju
accused
Nayak.
persons are there? Who was holding what? Why are you telling all the history? Tell me the nature of injury. What was the offense of weapon? Which part of the body? These are the three things. This happened.
ମୋ ଭାଇର ମୁଣ୍ଡ ହାତ ଦେହକୁ ହାଣି ପକାଇଲା ଯାହା ଫଳରେ ମୋ ଭାଇର
That's what
ଶରୀରର
I'm asking.
ବିଭିନ୍ନ
You
ହାତରେ
said that
କ୍ଷତ
lathi. Then it is sword injury.
Yes.
Sword injury.
Yes.
Yes. Who has given the sword blow?
Yeah.
Raju.
Petitioner, yes. Petitioner.
And who has given the lathi blow?
Raju Manti ତାର ପୁଅ ରିଷି.
Rishi has given.
Yes.
No. Read it. Read the.
ଗତକାଲି ପ୍ରାୟ 11 ଘଟିକା ସମୟରେ ମୁଁ ମୋର ଭାଇ ସୁଜିତ କୁମାର ମହାନ୍ତି ଆମ ଘର ଆଗରେ ଛିଡା ହୋଇଥିବା ସମୟରେ ଆମେ ପଡୁଛି ରାଜୁ ମହାନ୍ତି ପିଟିସନର ତାର ପୁଅ ରିଷି ସ୍ତ୍ରୀ ଚାନ୍ଦୁ ବିନା କାରଣରେ ଆମକୁ ଅଶ୍ଳୀଳ ଭାଷାରେ ଗାଳିକୋଜ କଲେ ଏହାକୁ ମୋର ଭାଇ ସୁଜିତ ବିରୋଧ କରିବାରୁ ରାଜୁ ମହାନ୍ତି ଗୋଟିଏ ଖଣ୍ଡା ଆଣି ମୋ ଭାଇର ମୁଣ୍ଡ ହାତରେ ବେକକୁ ହାଣି ପକାଇଲା ଯାହା ଫଳରେ ମୋ ଭାଇର ଶରୀରର ବିଭିନ୍ନ ସ୍ଥାନରେ କ୍ଷତ ହୋଇ ପ୍ରବଳ ରକ୍ତସ୍ରାବ ହେଲା ଏହା ଦେଖି ମୁଁ ମୋ ଭାଇକୁ ତା କବଳରୁ ଛଡାଇବାକୁ ଚେଷ୍ଟା କଲା ବେଳେ ସେ ମୋ ହାତକୁ ମଧ୍ୟ ସେଇ ଖଣ୍ଡାରେ ହାଣି ପକାଇଲା ବର୍ତ୍ତମାନ ମୋ ଭାଇର ମୁଣ୍ଡରେ
Show me the medical now. What are the corresponding injury?
Let's see.
Sword injury is there.
Frontal head 9/1 that is simple in nature. That another is left thumbs that is simple in nature. Left arm simple in nature, but assaulted in the tier 3 dressing common in that is the grievous in nature.
Where grievous in nature? Where? Which
That
part
is
of the body?
common in the eye metrirangeals parallels means on the side.
On the side. Yes, and Weapon, nature of weapon used. Medical,
That is
medical,
sword.
medical,
Sword.
medical, see, medical opinion.
No, that
Blunt
has not
weapon,
come.
what?
Only injury report is there, where it is not there. Then on what basis?
What is the recovery from whom?
The recovery. Yes.
From whom? These are minimum things you should know in 307. I need not spend, keep it Tuesday. Tuesday, yes, next. These are minimum thing. You don't tell me the history, what had happened. Tell me the injury, which part of the injury.
All injury are simple.
I understand whether recovery or not, because you have used it more. Yes, next.
Rejection order.
Next. 5.
Please.
Two antecedent also there in similar nature.
28 grams.
Sir, 70-80 matters are there. I can't waste time. More than 2 minutes, bail matter should not take. Yes.
21B of the NDPS Act, my lords.
Recovery?
28 grams of.
28 grams?
28 grams.
Grams. And
Cost addition 16/5/2024.
16/5?
24.
24.
My lords.
Yes. CD is not there. CD Tuesday next week. Yeah? Call for CD.
56.
Yes.
May I please?
Yes.
In this case, my lords, petitions has been substituted for the alleged commission offense, my lords, 294. 294 and seizure for of IPC, my lords.
Yes.
And he is in custody since, my lords, 23/2024, my lords.
20?
23/2024.
23/2024. Okay.
Charge sheet filed on 31/5/2024, my lords. Allegation not, my lords. While there was a marriage function or feast, my lords, of our nephew and the present infant and along with the deceased, along with the other family members who was present there for preparing food, my lords. My lords, at the time that he.
What are the offenses?
294, 304, my lords.
Okay.
Cause of that, due to, my lords, the present persons post the deceased.
Charge sheet filed?
My lords.
When?
On 31/5/2024.
31/5/2024.
24. Okay. Yes.
The present person post the deceased, my lords, and for which
you have. The problem is I am searching for the FIR number and all, because you have not filed anything except the rejection order.
Certificate copy with me. The FIR certificate copy with me.
If you keep yourself, then you also write the order for yourself.
No, sir. At the time, the Xerox copy not visible.
Subsequently, when you got, you should file it, and I am struggling to get the fact is not there, nothing is there. File the documents.
File the statement of the informants.
File the documents, sir. Unless you file the documents, how will I read at least? File the document. Minimum document at least file. Copy of FIR at least, if not anything else. Madam, Learned Counsel for the petitioner seeks 1 week time to file additional document to substantiate the case.
Next week,
this is the matter next week. You please file.
Yes. Today I have filed.
Yes.
57. May please your office. The petitioner
madam.
has been taken in custody
Yes.
on 25/5/2023.
25/5/23.
Lordships.
Okay.
The alleged offence is under section 420, 294, 506, 34 IPC. Chart.
Notice was issued to opposite.
They have appeared, Your Lordships.
Appeared, yes.
I am for the informant.
Informant, yes. How much you have taken?
Your Lordships.
62 lakhs.
Huh?
No,
62 lakhs.
No,
Wait.
The amount
Let
Your
us say.
Lordships, I'll fairly submit 96 lakhs was what was initially invested. Out of which 50 lakhs I have provided in material. Another 46 lakhs also I have given to the due as on date is 28 lakhs. According to my calculation.
Will you pay it?
Not the entire amount.
Well, similar.
Why don't you settle it?
That
I'll
is what-
grant bail and refer it to
That is
mediation.
what I am praying, my lord. That is what I am praying for.
What I'll do is I'll grant bail and refer it to mediation.
Yes. Yes, lords, do that. One thing, my
Because
lord.
if he will be in the custody, these are not recovery proceedings, you know that.
I know that, man. I agree with my lord. I agree with my lord. Sorry, sir. I fully agree, my lord. But the charge sheet shows that that is 63,94,200.
See, that is the amount
Yeah, see, I can't calculate it. He's
No,
already in
that's
custody for
I am
about
not
a
saying
year.
anything, my lord. That is there in the charge sheet.
Therefore, I am granting in the bail with a condition that she will participate in the mediation process and try and finish the matter, and you can file 482 and get it passed if you are satisfied. Yeah.
In connected matters, Madam Justice, the nursing has, my learned friend was appearing. He has granted some bank security and the DD along the property security that in addition.
There can't be a direction. If she agrees, I can verify to.
Yes, because she herself. She herself has argued this matter. This
In that case, the amount was 12 lakhs.
No, 12.
I have never been unfair. In that case, the amount was 12 lakhs. So I have given a deposit of 2 lakhs.
How many people you have cheated, by the way?
5%. In Odisha, 5%.
In Orissa, there are total four cases pending. Yes, 4 cases and 1. I have the antecedent affidavit if your lordship will like.
And what about the other cases?
All
You got the
cases
bail.
been resolved. This is the last case in Orissa.
And
According to mine.
in Orissa and elsewhere?
Elsewhere, no. Lordship.
No,
One
yes.
case only.
I have known that else all over India there is about 32 cases.
Now,
No, that is what I am saying. If you are treated
To demonstrate your bona fide, you deposit something.
Yes.
And I'll release you on bail and send you to mediation. That's the only way.
That is the only solution. I agree with you.
I can't keep her for eternity in this.
I agree with my lordship.
Lordship may say 2 lakhs.
Wow.
2 lakhs take it, 2 lakhs.
2 lakhs, 62 12 lakh 2 lakh or 62 lakh.
Hey, 12 lakh here, what is his proportionate? Maintain the proportion.
They're also paying 2 lakhs. The husband is in custody. So the lady, and in that case, I've also filed medical documents. The daughter is sick. She's
Wife is absconding.
Wife absconding. The fight
See, I'll tell you, take 2 lakh, I'm sending to mediation.
2 lakh, lordship.
And that is a condition of bail.
No,
Mediation is a condition of bail.
I agree with her. But lordship, at least minimum 10 lakhs. Because of 62 lakhs.
I can't say because if you can't pay, then
it's not possible to pay. Lordship, in that case, it was.
there can't be a direction.
Let it 5 lakhs, my lord. Let it 5 lakhs, man. Because I'm fairly considering to my suggestion. I agree.
Make it 4. Make it 4. Huh? Because 12 lakhs to 2 you have given. 28 at least.
It is not the case for bargaining, Lordship. So Lordship may direct.
Madam,
Do the
petitioner is accused in so and so case, and allegation is petitioner. Mr. Naidu will call for the petitioner at the outset submit on the instruction from his client that he would be depositing 4 lakh rupees to demonstrate her bona fide. Since the petitioner is in custody since 25/5/2023, I'm inclined to enlarge the petitioner on bail, subject to the following condition. The petitioner shall participate in the letter shall be remanded to the High Court Mediation Cell for the purpose of exploring the possibility of settlement. The coordinator of the mediation cell, state High Court Mediation Cell, shall fix a date and intimate the same to the concerned party concerned, and the petitioner shall cooperate in the mediation process. With the aforementioned sanctions, which shall be released or bail, with any other condition being fit and proper by the court in CC. 4 lakh.
Date is fixing, my lord.
No, the mediation center will fix the date and intimate you and participate.
Not
If you can settle the dispute, why not? Yes.
58. I'm sorry.
May I please? Custody since
Ms. Naidu will start now going to other state for bail in different high courts.
Super mine with 32 cases are all over.
She will roam around the entire country.
Yes, I have only 5. In an affidavit, yes, 5. Now he said 32 is increased.
Because these people are lost money, they are searching about all over.
This is a pleasant surprise for you.
You go
No,
there.
not a surprise. He's multiplied the number actually from 5 to 32 in a matter of a week.
It is a fact.
He
I'm doing the number.
has filed the affidavit saying that there are only 5 cases pending in the other case.
In Orissa.
No, entirety. He filed an affidavit in the other case saying that there are only 5 cases pending. And now he says 32. So now
That is not in Orissa, all over India.
no, all over India. Whatever it is.
Anyway, yes.
May I please?
Offense under 2B.
It is not say NDPS 9 kg ganja, but CD is not with it.
CD, call for CD, 1 week after. Okay, yes.
59.
Item 59 I may be permitted, my lords.
Sorry to disturb at this stage. So in the batch case, in respect of one case, there is a mistake of the case number. I have given the.
Give, I told him to give in writing. Yes. Give it writing, otherwise you will never come out. Yes.
Item 59 I may be permitted.
59, huh? Yes,
Item
yes, sir.
My lords, it is a case of 306 IPC, my lords.
Yes.
And the prosecution case is that the deceased Sagar Behera
You are
was
in custody since?
custody 15/4/2024, my lords. My lords.
15/4/24, okay.
My lords, prosecution case is that the deceased Sagar Behera was caught red-handed while committing sexual assault on the wife of co-accused Gurubha Murma inside the jungle, taking advantage of her loneliness, my lords. And the co-accused Gurubha saw the incident and assaulted the deceased, so also his wife, my lords. And other 5 co-accused persons also participated in the assault. The
Assault to whom?
To the deceased.
Sagar.
Sagar Behera, who was seen committing sexual assault on the wife of a co-accused. The deceased was confined in the house of the village chief so that a meeting can be held on the next day for the resolution of the dispute, my lords. But the deceased in the night, my lords, committed suicide due to social stigma and लोकोलजिया से allegation जहाँ सुजी जे लोकोलजिया पाई की से suicide वाला से लाइट रे मोटा statement may I place, my lords. My lord, statement of Silu Hembram. Statement of Ghana Bage, my lords. Statement of Silu Hembram, my lords. I am placing the relevant person, my lords. गत तारीख 22/4/19 समय पाखापाखि 11:30 घटिका हेब आम गाँ बासुकी तला शाल जंगल पाखरे हो हाला शुणी मु सेठाकु जाई जानिबाकु पाइली जे सागर कुमार बेहरा डिसीज्ड गुरुभार स्त्री लक्ष्मी मुर्मू को बासुकी तला शाल जंगल रे खराब काम
What is the name?
गुरुभा मुर्मू र स्त्री लक्ष्मी मुर्मू को बासुकी तला शाल जंगल रे खराब काम करुथिबा समय रे गुरुभा अलियास बस्ता मुर्मू जंगल काठ नहीं फेरुथिबा बेले निजे देखी शाल लाठी द्वारा 2 जन को प्रथम पिटिला और तापरे गाँ वाला को डाकिला डाक शुणी गाँ रु अनेक लोक सेठाकू गले और सेथि मध्यरु गुरुभार 2 भाई मुचिराम आलियास हगरा सालखान आलियास बिजू घनबागे पिटिशनर एंड सुंदर मोहन हांसता ओ सिंगल सिंह पिता सो एंड सो एमाने मिसिकी पिटामरा कले सेही समय रे खबर पाई सुपरवाइजर बाबुली राउत ओ काम करुथिबा मोटू सिंह आसी पहुंचिले सुपरवाइजर आसामी मानकू पिटिवार कारण पचारिबारु से ही 2 जन को मध्य लोक माने पिटिले जहा फल रे बाबुलीर आंठुरे खंडिया हला तांकू जीवन रे मारिबाकू धमक मध्य देले ताकू अटक रखी कंट्राक्टर को डाकिया पई सुपरवाइजर को कहिले तार आसीबा पर्यंत सेठारे अपेक्षा करिए बोली कहिले कंट्राक्टर न आसीबारु आसामी मानक मध्य रे स्थिर हैला जे सागर बेहरा डिसीज्ड ओ गुरुभार स्त्री को गाँर मुखियांक घरे आसंता काली मीटिंग हेबा पर्यंत रखा जिवो कंट्राक्टर आसिले विचार करा जिवो बाबुली राउत और मोटू सिंह ग्रामर मुखियार घरे ग्रामर लोकंक सहित मिसी सागर को छाड़ी
How many accused persons are there? Yes.
6 accused.
5. And allegation against all the 5 are same. Same.
They both started fast, but that is the things. Here, he himself read it. Bage Kuna.
He is brother of Guruva.
Aye, Gana says.
Samaste.
Three High Muchiram, Agarasai, and Bichu Ghanabage. Which is the petitioner here.
So, कहते all. So, गोटी move पढ़िले समस्ते all.
They started first, then other accompanied him.
But he didn't die.
You got the CD, no?
Yes.
What are the evidence according to you?
Evidence, I mean, they both have said that Maheshwar Mahanto, Nobin Ramkudia, and Bulu Mahanto, Shyamacharan Singh, they all have seen the
giving
assaulted part.
assaulted.
Yes.
But the fact,
after that close of the room when they were kept, that
Yeah.
part what has happened in the room, no one has seen it.
But it is 306 you have filed.
yes, charge sheet 306.
306.
Rejection order also shows 306.
April. And what is the stage?
Charge sheet
Charge sheet filed when?
charge sheet submitted 2020 Millers, but
Date.
trial has not progressed Millers.
No, charge sheet on no.
Date.
Charge sheet date Miller, much prior to the present rejection Millers. I am submitting the date Millers. The date is 31/3/2020. Long before Millers.
Then let the witnesses be examined because
Yes.
you have brutally assaulted that man
No, Millers.
by tying him. You brutally assaulted, and thereafter you put him in a room.
Yes.
And
My
in the night he has committed out of humiliation and frustration.
My lord's rejection order shows that all other co-accused persons have been granted bail Millers. Rejection order itself says Millers. Others again again.
So where is that? Where is that?
It is stated Millers, that is page 11.
How many? How you and who has given a blow? First assaulted.
First
You
assault.
and-
No, Millers.
Brother, Bagher.
You
And his brother.
and he and along
His
with
brother.
Huh?
He and his brother, Lordship.
Who is that? His
Yeah.
brother.
Let me place the statement again. My brother is confused. Millers.
Guruva.
Guruva has been granted bail.
No.
Guruva has not been granted bail.
No, Guruva has been granted bail. All
Where is
other,
that? Show
Where
me.
is that order?
Show me Guruva.
yes,
Show me.
all others have been granted bail, Millers.
Where is that? You show me that.
Guruva,
Like Mochiram Hagara, Salman Khan, that is Ghonobaga, this is the petitioner here.
Guruva is the person who first assaulted Millers.
First
Sir,
assaulted.
you show me where Guruva has been granted bail. You have not filed anything except rejection order. I am struggling to get.
But the rejection
This is
order.
the kind of petition you people file. You don't say anything. I have to keep on searching. Where from I'll get that Guruva has been granted bail? Have you pleaded that? Have you said that anywhere?
Paragraph
Even
4.
charge sheet is not filed.
My lord, rejection order shows Millers. My rejection order page 11 para 4 Millers. Millers para 4. Pair with the case record. This is a case under section 341, 323, 342, 506, 306, 34 IPC. And the IO has submitted charge sheet on 31/3/2020 showing the petition as absconder. No doubt that some of the co-accused persons have already been released on bail by this court. But this petition is not similar because se abscond thila kis din sepa me कहउचंती. But Guruva is the person jaha wife सहित sexual assault करुथिबा बेले से धरा पड़ला. That intention motive was with Guruva.
Sir, I am asking something. Why are you not answering? Show me from the record something that Guruva has been granted bail. So
Guruva
that on the parity I will grant you bail.
Guruva order is not with me,
You
Lord.
understand? You don't want bail, it seems.
But I am on a better footing
Please it
than
after 3 weeks. Please it after 3 weeks.
no,
Yes,
Millers. One prayer, Millers.
Next.
One prayer.
No. You don't file any document. I am asking something. You're
One prayer, Millers. I may
Item 60, my lord.
Yes.
As for noting, my lord, there is a prisoner petitioner in my name.
Millers, I may be for.
documents at least. This is very. I don't understand.
My lord.
Yes.
No, Lordship. 60 citizens.
60. Yes.
My lord, there is a prisoner petitioner in my name. As for noting, your lordship.
What do you want?
My lord, the ganja is only up to 5 kilo 900 gram, my lord. Petitioner custody since 16/5/2020.
5 kilo.
My lord.
Ganja.
My lord.
Granted bail.
With any stringent condition, they are local person, my lord.
Custody since?
Custody since, my lord, 16/5/2024.
16/5/2024.
My lord.
5/24. Granted bail, subject to verification. Yes.
Antecedents.
Antecedent. Okay.
Pardon, my lords. I may be excused, my lords. Item 59, I may be permitted to move the court below, my lords. That is the only thing, my lords.
I'm not rejecting, sir. What I'm saying is at least I was interested to grant you bail. You don't file anything. You show me Guruva has been granted bail by the trial court. I'm not rejecting.
True,
I'm putting it after 2 weeks. Please
Lord.
file the documents.
My lords, your lords may dispose with liberty to move the court below, my lords.
Yes, sir.
I'm ready to grant bail anyway. If you want to do that, it's all right. All right. Learned counsel for the petitioner seeks to withdraw the petition to renew his bail plea before the trial court on the ground of parity. Parity, as all other co-accused persons in the present case has already been granted bail. However, his bail plea was rejected only on the ground that he was absconding. However, he has already been taken into custody, and he is in custody since 6/2/2024. On this changing circumstances, petitioner seeks to withdraw the petition to renew his bail plea before the trial court.
Custody date, my lord, custody date is 15/4. Custody date is 15/4/2024.
15/4/2024. Okay.
Well, item 60.
After 61, I seek only 1 day to file.
Lordship 60 granted. 60.
Only one, only one day only. I will file the report. Your lordship ask me. If I ask for, I will file the report.
Thrice, my lord, he has taken time.
I have said tomorrow. If you are
Friday.
keep also I will there.
Tomorrow I will agree, my lord. Tomorrow.
Tomorrow or Monday.
No, Monday. Tomorrow.
Because I have prepared. Half of that I have prepared, lordship. For that only I am saying. Otherwise, it is not. Because so many documents I have got it, and I.
So let it be tomorrow.
Tomorrow, further, if it will not, then again I cannot ask the time. Monday it will be no doubt. Monday I will.
आपने पूरा फाइल ले पढ़ो तो मासे खंडे
No, I am not on that part.
What is the offense?
आगे offense किसी नहीं केवल I have lodged an FIR against the IIC. For that reason, in 2015 matter, he has gathered some.
He has gathered without any affair.
But that is my case.
For that only I seek.
He has gathered some person of the locality and lodged FIR one after another.
Without earning a person, he is having 80 crore, more than 80 crores of the.
अरे 80 crores है से एक case
income tax pay.
से सब गुड़ा खोल के
Let him.
Tomorrow.
You try tomorrow. If it doesn't happen, yes. Right. Tomorrow. Let it be Monday again. He'll ask tomorrow.
Monday मुझे कैसे करीबनी पुनी तेजी जो कहा
I'll make it. I'll make it.
काली करूँ तो काली से पढ़ के गोटे फाइल दूँगा अलग हो
गोटे
फाइल अलग हो स्पेशल काउंसिल दूँ
I can't say that how many cases will be allotted to him.
ना ये स्पेशल हो तो
Tomorrow and Monday.
And you won't tell the advocate general only in this matter again. Give it on Monday. Otherwise, he's
last chance.
Last chance. On the request of learned counsel for the state, the last and final opportunity for the matter is fixed for Monday. It made clear that no further adjournment. 5 cases, huh? 5 cases. You prepare a chart also.
For that only I am
in
saying.
which case,
yes.
So that we'll not waste time.
Yes.
3 cases.
3 cases.
3 cases. Whatever
chart बनने easy. Yes. Yes, sir. 62.
May please, your lordship. Your lordship, the petitioner in custody since 21/9/2023.
21/9/2023.
And the charge sheet in this case has been submitted on 16/11/2023. For the alleged offense, my lordship, under section 363, 366, 367, 376 2N, 294, 506 of IPC, read with 6 of the POCSO Act, 9 of the Child Marriage Act, and section 31 RS and 32B VA of the SC and ST Prevention of Atrocity.
appear victim through VC, but today it was posted to. Today it was not the date. Previous order is there, lordship, to through VC.
Where is that? Which order?
12/6/2024.
10/7/2020.
Is noticed to the victim.
The 10/7/2024 was fixed.
Case
My-
diary is there.
Yes. Only
What is your instruction? Have you
76D there.
unable to cause unable him to cause the notice? Service देखो. Service see. Have you served?
We have served one copy to them.
Huh?
Yes, we have served one copy. Actually, date was not today. For that only, it is impossible to her to appear. 10th July 24. it was
Okay,
dated.
right down. By the order dated 12/6/2024, the coordinate bench of this court has directed to serve the informant, victim of informant through the IAC PS, IAC of concerned PS for appearance there is no indication of appearance
10th July. Let's say.
for
10th July.
For 10th July 2024. But the matter could not be taken up on that day, as a result of which the victim informant could not appear. The State Council is directed to re-intimate the date of hearing, next date of hearing to the informant oblique victim. Please the matter date fix and re-intimate.
My lordship, the date when fixed.
Yes. 23rd. 23rd. Yes. 63.
May I please? Final PR has already been submitted. Petitioner is a poor driver. No criminal antecedent. It can be evident from the page 9 of my brief. The IO revealed that he has not involved in any criminal cases.
Custody?
Since, my lord, 13/4/2024.
13/4/24.
My lord. In the meantime, final PR has already been submitted.
Offense?
20B to C.
Recovery?
80 kg. Theft.
Yes, CD is there.
No, CD is not come.
Final
CD
PR.
next week.
Only PR, my lord.
CD, call for CD. You also have done the same thing.
My lord.
Except rejection order, there is nothing. No FIR, nothing.
Can I say before lordship? After getting consent, I have appeared. I have got that entire.
But you
next week, my lord.
Meanwhile, file.
Next week. Next
call for CD, because even if I grant bail without calling CD,
because I have got that certified copy. From the certified copy, I have.
80 kilo, I'll grant bail, but less than 100, then I generally.
Next week, my lord.
Yes. Call for the CD.
It will come from Denkanal, near.
Yes.
Next week.
But meanwhile, file.
My lord.
Yes. 64.
64, my lord. My lord, petition number 1 is in custody since 22/11/2023.
22?
CD is not with.
11/2023.
CD is not there.
My lord, one thing may I call? I have the certified copy of the entire document.
Give it to.
Yes.
Huh.
It may be taken over
23rd. Okay, 23rd.
Absolutely,
Meanwhile,
proper the present.
CD may be called for, and then counsel for the petitioner submits that he has certified copy of the entire charge sheet. The copy of the same is supplied to the State Council. Yes, State Council.
What
For
copy of the-
verification. Leave the matter on 23rd. Yes.
65.
Yes. Yes, sir. 65. State to verify criminal antecedent.
Yes.
Verified.
It is not come. Let's say I have asked for
The
yesterday.
by the order dated 18/6/2024, the State Council was directed to obtain the instruction regarding the antecedent, criminal antecedent of the petitioner. The same has not yet been received by him, and leaves the matter after.
Hello.
Yes.
66.
May I please? Offense under section 302, man. Sole accused. Sole accused.
Yes.
Arrested on 9/8/2023.
9/8/23.
My lord.
Yes.
Charge sheet submitted on 30/9/2023.
39/23. Yes.
My lord. My lord, there is no eyewitness to the occurrence.
Yes. What is
And-
that?
My lord.
What are the allegations against him?
Twenty-seven, he is admitted under section 27. There too, I am reading the
Non-living to prompting को लोग है क्या ना material थे लोग ना
Yes.
27 is सुना उड़ा
What is
ମୋ
the
ସତ୍ୟପାଠ ବହି କି ଯେ 2:23 ରାତି 10টাରେ ପାଖାପାଖି ମିଥୁନ ତାଙ୍କ ସହିତ ଗୋଟିଏ ତାଙ୍କଠାରୁ ସାନ ଦିଶୁଥିବା ଝିଅଟେ ଧରି କିଲୋରା ଗ୍ରାମର ହଷ୍ଟେଲକୁ ଆସିଥିଲା। ସେ ହଷ୍ଟେଲରେ ଦୁହେଁ ରହିଲେ। 4/8/2023 ସକାଳ 4:05 ପାଖାପାଖି ସେ ଦୁହେଁ ତାଙ୍କ ସାମାନପତ୍ର ଛାଡ଼ି ହଷ୍ଟେଲରୁ କୁଆଡ଼େ ଗୋଟେ ପଳେଇ ଯାଇଥିଲେ। ଆମେ ତାଙ୍କୁ ଖୋଜିଲୁ ବହୁତ କିନ୍ତୁ ପାଇଲୁ ନାହିଁ। 8/8/2023 ଦିନ ମିଥୁନ ଆମ ପାଖକୁ ଆସିଲା। ସେତେବେଳେ ଆମେ ସେ ଝିଅର ଖରାପ ଭିଡ଼ିଓ ଦେଖି ସାରିଥିଲୁ। ମିଥୁନ ସନ୍ଧ୍ୟା 7ଟା ପାଖାପାଖି ଗୋଟିଏ ବାଇକରେ ଆସିଥିଲା। ଆମେ ସେ ଝିଅ କୁଆଡ଼େ ଗଲା ବୋଲି ପଚାରିଲୁ। ମିଥୁନ ପୋଲିସ ଆସି ମିଥୁନକୁ ଧରି ନେଲେ। At that moment at hostel.
He is an independent witness.
27 also he is admitted.
No,
That by stone.
Whose evidence is that?
Petitioner 27.
The
Here is hostel. On which hostel last night where they stayed there?
Last scene.
They are
Last scene.
owner of the hostel.
Yes, last scene is there.
Yes.
And what else? 27 last scene. And
Yes.
what else? Any recovery?
Recovery after the 27 statement when police took him and
Dead
they
body was recovered.
recovered that stone on which he threw it.
Dead body is not.
Dead body she thrown in the water.
Dead
there.
body recovered at whose instance?
Yes.
an unknown dead body was recovered by local
That is there. That
they informed to the police. The police
Identified.
police after that the father of the petitioner my lord came and lodged an FIR.
Also, the postmortem report is also there. Also, that is
Read
that
the
is
postmortem.
lacerated wounded on the 5x6 cm bone deep present in the right frontal parietal area. Scalp over the missing 5.4 cm bone deep over left lateral aspect eye and upper
The fact is
malar
that you have taken this girl to hostel.
Yes.
Stayed together.
Yes.
In the morning you went.
Both are laborers. Both are labor class. We went to that spot, that hostel for labor work and resided there. On the next morning, both are left.
The dead body was found subsequently.
It was on the missing report on 4th man. The
Let the witness be examined.
my lord 3/8 my lord the victim left her village man.
Let these
And that statement my lord on 4th after the dead body was recovered on 8th. So my lord that is if that is a last scene theory my lord that is most a time gap. Time gap is immediately my lord.
Let this witness be examined. They are independent witnesses. Right, and petitioner is accused and so on. So the listener is the petitioner and so on. So he is the petitioner is in custody since 9/8/2023. Against the petitioner, the prosecution has alleged alleged that he was seen last week. The deceased was seen last week with the petitioner, and the petitioner has also given confession
Bijugoda Santosh Pradhan.
leading to recovery. And there are independent witnesses. There are
Bijugoda and Santosh Pradhan.
However, liberty is granted to the petitioner to renew the bail fee after the independent witness.
Your lordship Biju Gowda and Santosh Pradhan.
Biju Gowda, namely Biju Gowda and Santosh
Pradhan. 164 statement.
Record.
67.
The offense is 302, my lord.
Yes.
My lord, allegation as per the FIR, my lord, one UTP Charana Behera, while he was in jail custody, my lord, has any expired, my lord, for which UD case number has any registered, my lord. During inquiry, my lord, the informed came to know that the deceased is arrested and forwarded to the jail custody, my lord, for and stayed in the quarantine hall. In quarantine hall, petitioner has assaulted the deceased, my lord. That is the allegation, my lord.
Yes.
As per the allegation, my lord, the FIR was occurrence took place on 15 July 23, my lord. and FIR has been lodged after 17 days, my lord.
17 days.
Yes, my lord. In the meantime, 2 witnesses already examined, my lord. Jail order, my lord.
Custody.
Custody since, my lord, 18/8/23, my lord. In the meantime, 2 jail order has been examined, my
One
lord.
similar antecedent is 302.
ସେ କେସରେ ସେ ବେଲ୍ ହେଇଗଲାଣି ବର୍ତ୍ତମାନ ବେଲ୍ ହେଇକି ସେ ଅଛି ସେ
And when these witnesses were examined?
Your examiner 24/7/24. Your kind
In order it has been reflected.
24/7?
24/7/24.
All the witnesses. How many?
Two witnesses out of 30.
They are the vital material witness.
Yes.
No.
To jail order, my lord, who was in duty, my lord, on 15, my lord, on the occurrence date, my lord.
So you renew your bail. Right, the petitioner is agreed by the order dated 22/5/2024, whereby his bail plea has been rejected. He is an accused in FIR number so under section 2. In the counsel for the petitioner submits that on 24th July 2024, the evidence of PW1, two witnesses, evidence of 2 vital witnesses have already been examined. One of them is the jailer of the.
Both are jailer order.
Both of them are the jailers in which the occurrence arrest to have taken place. In view of the changing circumstances, the petitioner seeks to renew his bail plea for the court below, and if such application is moved, since the consider on the basis of available on the court within 15 days. Yes.
69.
When I filed the interim bail application, my lord, including the document, medical document, my lord, can you glance to anesthesia enclosure A? In the IA, my lord.
IA number?
IA number 1204.
Yes.
My lord. Here, my lord, the jail medical officer, Circle Jail Cuttack, has sent a report to the senior superintendent of Circle Jail, my lord.
Yes, what does
My lord, the OPD card visit, page 7, my lord.
Yes.
The advised for the colored Doppler, my lord. For testing of the color Doppler is not available in the SC Medical College right now because of the fact that
they'll take you in custody and do it. They'll take you. What is the offense?
Offense.
Economic offense, my lord.
Lordship, may direct for the taking the instruction about
Fraudulent
that
claim you have taken away 3,70,00,000 by making 35 fictitious account, my lord. He is the bank manager of the IDBI bank. CD also not available.
My lord is hearing the main bail application today, my lord. Pass it through, Mr. Shorting will ask this matter.
No, main case diary is not available.
Call for case diary after 2 weeks. Yes.
My lord, for I why I am submitting, my lord. So, lordship, can you glance to paragraph 6, my lord?
In the meantime,
what is
the petitioner, the jail authorities are directed to take necessary steps for what is that?
Taking instruction about the status of the patient.
You have given that. What is that test? They will take.
My lord, test, my lord.
No, my lord, kindly have a glance to my lord. Annexure enclosure A, my lord. He was advised medicine and color Doppler radiological test of BA lower limb. Color Doppler test is done and to be reviewed after report by CTVS because CTVS department not given report. At present, his condition is stable. This is the report, my lord.
My lord, the solemn offer to tie and the private party is concerned. It is very serious, my lord.
Very serious, but you are stable.
No, my lord, it is stable in the other parts, my lord.
Verified by two.
That is verified after the case.
Verify the health condition and come. Yes.
Along with the option CD, my lord.
CD. Verify the health condition of the petitioner and obtain CD. Next.
My lord, 1 week, my lord, because of the
next.
70.
70.
My pleasure also. I'm filing power today. Item 70, Mr. S.R. Pradhan and associate name may be deleted.
Yes.
And the offense under section 392 and 420 along with other offenses. And custody since 3/34/2024. 30. And 30. And remand on 7/3/2024. All the offenses are triable by magistrate and is in custody, and other co-accused person already released on bail. Three accused persons are there. Altogether, 3 accused persons are there in this case. Out of 3 accused persons, 2 accused persons are already released on bail.
Here, my lord, man of MP, my lord, having 15 criminal cases in the our state, my lord, and rejection order shows, my lord, he has some cases in the other state like Karnataka also, my lord. And if now Puja is coming, my lord, he will.
I am submitting.
File
Page 13, Lordship, kindly see.
File affidavit.
No. What I am submitting, 3 accused persons are there. All 3 accused persons are 15 antecedent. All are belongs to outside. Page 13, Lordship, kindly see. Page 13. Page 13, yes, my lord. All 15 cases against all 3 accused persons. Very last para, my lord. Verified CA of accused persons, namely Raja Ali. I am the petitioner. And number 2 is the Jafar Hussain. And number 3 is the Hassan Ali. Jafar Hussain and Hassan Ali already released on bail by the Leonard Court below.
They how many cases?
Same, my lord. All remand cases. 15 cases, my lord. Kindly see. All. So page 13.
Miller, next. And in the meantime, let him file.
Or I pray, my lord. Because I pray, my lord. I am filing this application on 10/6/2024. Thereafter, the present petitioner released on bail on 8/8/2024. The lower court will verify whether I am in same footing or not. You will consider lawsuit disposal.
Which item? 70. Land Counsel for the petitioner submits that his bail plea has been rejected on 20/5/2024. Subsequent there on
Rejected. I filed on 10/6/2024.
Give the date when the other people were granted bail.
On 20/5/2024. 25/2024. Page 16.
When the other co-accused person
8/8/2024.
8/8/2024.
Namely Jafar Hussain and Hassan Ali.
8/8/24. 2 co-accused persons,
Jafar Hussain and Hassan Ali.
Hassan Ali has been granted bail. The Land Counsel for the state submits that the present petitioner has 15 criminal antecedents.
In our state and also some in Karnataka.
And in state of Orissa, and there are some other cases pending in Karnataka. The Counsel for the petitioner per contra submits that in so far as the co-accused person Hassan Ali and Jafar Hussain are concerned, they also have the similar antecedents.
Same.
Despite that, they have been enlarged on bail. Therefore, he submits that he would renew his bail plea before the trial court on the ground of parity, apart from on the ground of parity, apart from on merits. Merit, if such application is moved, the same shall be considered within 15 days.
Oblige. My Bakalatama kept on record.
Bakalatama taken out.
71. May I please?
Yes.
Petitioner custody since, my lord, 4/8/24.
Sorry.
28/4/24. 28/4/24.
28/4/24. Okay.
Charge submitted 4/8/24.
4/8/24. Yes.
307 along with other offences, my lord. The petitioner
Charge
is
sheet is there?
yes,
sheet is
yes.
there?
Yes.
Petitioner is about 55 years, my lord, 51 years. The either neighbor of the victim, my lord. There's some dispute there between the family members. So
You tell me what are the injuries?
Injury, burn injury, my lord.
Burn injury.
Yes.
Yes.
Yeah, already recovered
Yes.
from the hospital.
No, I'm really curious. What happened in this case, my lord? Present petitioner, neighbor of the victim, my lord. When bride and groom were going to their house, my lord, he set fire on that Bolero vehicle. When the victim went to spot to rescue, my lord, he has sustained burn wounds. I am placing the statement, my lord, of the informant Harish Chandra Pradhan, my lord.
Yes.
ମୁଁ ମୋର ସ୍ତ୍ରୀ ଝିଅ ମିଶି ଗ୍ରାମରେ ଆମେ ସ୍ୱାମୀ ସ୍ତ୍ରୀ ବୟସ୍କ ହୋଇଯିବାରୁ ମୋ ଝିଅ ପଡ଼ିଶା ରହୁଥିବା ଜଗନ୍ନାଥ ପ୍ରଧାନ ପ୍ରେଜେଣ୍ଟ ପିଟିସନର ତ ଯିବା ଆସିବା କରିଥିଲା। ମୋର ଝିଅ ଈଶ୍ୱର ପ୍ରଧାନ ଜଗନ୍ନାଥ ମୋ ଝିଅର ପ୍ରସ୍ତାବ ଆସିଲେ ସେ ଜଗନ୍ନାଥ ପ୍ରଧାନ ସବୁବେଳେ ମନା କରିଥିଲା। ୟାରି ଭିତରେ ମୋ ଝିଅ ଲାଲମେଣ୍ଟା ଗ୍ରାମର ମିଥୁନ ପ୍ରଧାନ ସହିତ ବିବାହ ପାଇଁ ଠିକ ହେଲା। ଏହାକୁ ଜଗନ୍ନାଥ ପ୍ରଧାନ ମନା କରୁଥିଲେ ଏ ବିଷୟ ଯୋଉ ଜ୍ୱାଇଁ ମିଥୁନ ଜାଣିବା ପରେ ଜଗନ୍ନାଥଙ୍କୁ କହିବାରୁ ଉଭୟଙ୍କ ମଧ୍ୟରେ ବଚସା ହେଲା। ସେବେଟା ଜଗନ୍ନାଥ ପ୍ରଧାନ ଜ୍ୱାଇଁଙ୍କୁ ମାରିବାକୁ ଚାହୁଁଥିଲା। ମୋ ଝିଅ ବାହାଘର 26 ହେଲା, 26/4/24 ହେଲା ଆଉ ପରଦିନ ସକାଳୁ ଅର୍ଥାତ୍ 27/4/24 ଝିଅ ଜ୍ୱାଇଁ ଆମ ଘରକୁ ଲେଉଟିବା ପାଇଁ ଆସିଲେ। ଦିନ ସାରା ରହି ସନ୍ଧ୍ୟା 8ଟାରେ ଯିବା ପାଇଁ ବୋଲେରୋ ଗାଡ଼ିରେ ବସିଥିବା ସମୟରେ ଆମ ପଡ଼ିଶା ଘର ଜଗନ୍ନାଥ ପ୍ରଧାନ ପ୍ରେଜେଣ୍ଟ ପିଟିସନର ପୂର୍ବରୁ ଯୋଜନା ଭାବରେ ତାର ମୋଟର ସାଇକେଲ ଗୋଟିଏ ବୋତଲରେ ପେଟ୍ରୋଲ ବାହାର କରି ଘର ବାହାରେ ଛିଡା ହେଇଥିଲା। ଝିଅ ଜ୍ୱାଇଁ ଗାଡ଼ିରେ ବସିବା ପରେ ବଡ଼ ଝିଅ ଲକ୍ଷ୍ମୀ ପ୍ରଧାନ, ସୁମନ୍ତ ପ୍ରଧାନ ସେମାନେ ଜିନିଷପତ୍ର ଗାଡ଼ିରେ ଲଦିବା ସମୟରେ ଅଚାନକ ଗାଡ଼ି ପାଖକୁ ଆସି ଗାଡ଼ି ଉପରେ ପେଟ୍ରୋଲ ପକାଇ ନିଆଁ ଲଗାଇ ଫିଙ୍ଗୁଥିବା ସମୟରେ ଉକ୍ତ ନିଆଁ ଝିଅ ଲକ୍ଷ୍ମୀ ପ୍ରଧାନ ଉପରେ ପଡ଼ି ଜଳିଲା ସମୟରେ ସେ ଘର ଭିତରକୁ ଦୌଡ଼ି ଆସି ତାର ଶାଢ଼ୀ ଖୋଲି ନିଜକୁ ବଞ୍ଚାଇଲା।
Allegations are serious.
No, no, my lord,
What? No, this is the allegation. What to do?
already discharged from the hospital. He is held.
Then see, the intention was so.
Milord,
No, no,
milord.
no, there is
Intention has to be
dispute, there
seen.
is dispute, my lord, between the
Oh,
parties,
maybe.
between family members, my lord.
Eyewitness, eyewitness,
51,
Milord,
eyewitness.
yeah, so many eyewitnesses are there, milord.
sir, 51-year-old, my lord. My lord, kindly
So many
consider,
eyewitnesses.
my lord.
There are eyewitness to the occurrence. Since the petitioner is in custody since 28/4/2024. Since the eyewitnesses to the occurrence have made statement before police implicating the petitioner. Statement before the police.
My lord, permit to withdraw, my lord.
Specifically, I'm not inclined to.
Mala, he's praying to frame for withdrawal, milord.
Withdraw, renew.
And counsel for the petition seeks to withdraw the petition to renew the bail plea before the court below. And yes.
22.
May I please, my lord. My lord, the present petitioner custody since my lord
Milord,
8/1/20.
72, milord, 302 CD is required, milord.
CD call for it. Yes.
74.
My lord, short date me. Date, my lord.
Date will be given, yes.
74.
Sir, may I please, lordships? Lordships, the petitioner is a 25-year-old boy who is in custody since 21/5/2024, being charged sheeted for an offense under section 457 and 395 of IPC, your lordships.
Yes.
Your lordships, in this case, no witness or co-accused is implicating the present petitioner. No seizure has been made from the present possession of the present petitioner. No TI parade has been conducted.
Yes.
And
Milord, what happened in this case, milord? Present petitioner and others, milord, enter into the Punjab National Bank by breaking the door, milord, and taken away 4 camera, 4 computer, etc., milord. From exclusive possession of the present petitioner, milord, 2 computer has been recovered, milord, and he has involved in 4 cases.
your lordships, during verification of by virtue of an order passed in ABLAPL number 4208, the present petitioner has surrendered as he was apprehending arrest. And during verification of CA, police has given 4 cases against him, and all are remand cases of similar nature. That is 457 and 380.
You were arrested in which case?
I have surrendered in connection with this
Which
case.
case?
This case, your lordships.
And the other cases are.
Police has taken me on remand.
And similar footing, Satyeswar Bera has been withdrawn, milord.
Your lordships, from his possession, some material has been seized.
In
From,
your possession also.
Yes, yes.
from my
2
possession,
computer has been recovered, milord.
From your.
His possession, milord, CCTV recovered. His possession, computer recovered, milord.
your lordships, in the charge sheet, police has not written anything against me. No witness is implicating me. No confessional statement of the co-accused person.
Show me the charge sheet.
Your lordships, I have a certified copy of the charge sheet.
You have the CD with you.
Yes, yes.
Charge sheet, the see.
Yes.
Read which part. What are you doing? You, Acha. 25 years. Yes.
Your lordships, in the charge sheet, police has written that received information from CSI Jajpur that absconding accused person, namely Nilam Majhi, Nilam son of Mrityunjay Bhaji, has been surrendered before the Hon'Ble Court of SDGM Jajpur in connection with this present case by order passed in ABLAPL number such and such, your lordship. This much only written
No,
against.
that is not neither here nor there. What are the evidence you just?
Milord,
That is the evidence.
that is
The witness to the seizure and confession, your
The
lordship.
problem is your co-accused person has withdrawn it.
milord. Satyeswar Behera, milord.
Procedural error. Withdraw.
Milord.
That comes for the petitioner seeks to withdraw the petition to renew his bail plea before the court. When the charge sheet is filed?
Chief charge sheet was filed on 25/7/2024.
Arrested on 8.
25/7?
2024.
24, right. Petitioner is agreed by the order dated 21/5/2024, whereby his bail plea has been rejected. Subsequent thereto, on 25/7/2024, charge sheet has been filed. In view of the aforementioned changing circumstances, he seeks to renew his bail plea before the court below. Accordingly, the petition is disposed of. Yes. Bail
76.
75.
76.
Here, my lord, the sole accused person, my lord. Petitioner is the sole accused person.
Yes.
Arrested on the 4/1/24, my lord.
Sorry?
4/1/24 in custody.
4/1/24.
Lordship.
4
Charge sheet.
1/24.
Charge sheet filed on 1/5/24.
1/5/24.
24.
Okay.
Under section 302.
302.
Initially, FIR was lodged on 307. Thereafter, death, my lord, it was turned to 302. The background of the case is, my lord, the petitioner.
Now you have to renew the bail plea before trial court, because in the April your bail was rejected. Now the charge sheet is filed subsequently, May
5/1.
And petition is agreed by the order dated 3/4/2024, whereby his bail plea has been rejected. Subsequent thereto, on 1/5/2024, the police has filed the charge sheet in the present case. In view of the aforementioned changing circumstances, petitioner seeks to renew his bail plea for the court below. If such bail plea is filed, the same shall be decided on the basis of the material formed part of the charge. Yes, next.
78.
27. Withdrawn.
78 permitted to withdraw.
Withdraw. 78. Yes.
79.
May I please, Your Lordship?
Yes, madam.
Lord, this is a case under section 302 and 201 IPC.
CD is there?
No, CD not available below.
CD court copy. Yes.
My Lord, the last order was to for the state to obtain CD and
Yes, one chance. Miller.
Next.
80.
published.
May I please, Your Lordship? Your Lordship, since 19/6/2024, CD was called for. Allegation of
One chance, Miller. CD not brown sugar case, Miller.
55 grams of brown sugar, no antecedent, Your Lordship.
State council for the state seeks one more opportunity for obtaining the CD. Next.
81.
Maybe, Your Lordship. The petitioner is in custody since 13/3/2024, my lord.
30?
Yes, my lord. It's a case under section 376 2N and 6 POCSO along with other offences.
Yeah.
The age of the victim is, my lord, 17 plus, my lord. And the age of the petitioner is 21 years, my lord. And there was a marriage proposal and the victim was staying with the present petition family.
Yes.
And the petitioner.
164.
Yes, petitioner categorically stated, Miller, गत 9/3/24 तारिख ना दीपक हटा दीपक प्रेजेंट मिस्टर मते जोर जबरदस्ती तास घर को नहीं
Occurrence is 7/5/2024, my lord. FIR registered on 19/5/2024, my lord. After 12 days, FIR has been registered.
12 days.
Yes, my lord.
164.
Miller.
Victim is married woman, my lord. 2 sons there.
Yes, marriage. मोर स्वामी भीमकृष्ण साहू झारसुगुड़ा वेदांत रही काम करती मोर दुईटी पुओ अच्छी सासू दियर को नहीं आम घर आम सब रहू मोर बड़ पुओ को मुझे सबुदिन ट्यूशन करने सार पाक निए छाड़ा आसवा संध्या बेले गत मास जुलाई मास 2023 रे मु मोर पुओ को ट्यूशन आने को जाऊली जीवा समय मत एकुटिया आम गाँव बिंदुसार धल प्रेजेंट पिटिशनर रास्ता
the petitioner has possibly petitioner is sexually assaulted her. Subsequently, on 5/5/2023, the petitioner came to her house and sexually assaulted her again. When the when the neighbors saw the incident, they informed her husband, and accordingly the fire was registered. FIR was registered on 19/5. FIR registered after 12 days. That is on 19/5/2020. Petitioner is in custody since custody since 19/5/2024 regarding head to the nature of allegation and so on.
ଆଜ୍ଞା ସେଟା ଯୋଉ 5/5 କହିଲେ ସେଟା 7/5 କରିଦିଅନ୍ତୁ ତାକୁ ଆଜ୍ଞା
5/5/7
ମାଲଟ
83 yes
83 CD ନାହିଁ ଆଜ୍ଞା
CD call for CD CD interim bail for what
Mother expired.
mother expired huh? Mother expired when
No, these are solutions.
no 18th and 19th yes
ମୋ ପାଖରେ ଦେଇନାହାନ୍ତି କି କପି ଦେଇଥିଲେ ଇନଷ୍ଟ୍ରକ୍ସନ ନେଇଥାନ୍ତି
I told you that you should have given I will verify it tomorrow
ଆଜ୍ଞା tomorrow ଆସୁ ଭେରିଫାଇ କରିଦେବୁ
tomorrow
ଆଜ୍ଞା
because 18th and 19th September is the Cormo.
Director really subject to lower court or trial court verification.
Again verification same time.
हाँ दियंतु कोड
Better verify so that I
कॉपी
will
दियंतु
release straight away.
कॉपी टा दियंतु मिस केस टा दियंतु
Shall I allow it now and subject to verification of
My lord.
the trial court?
yes
The same day it will happen.
मिलर
Huh? Petitioner has moved the present application IA number 1280.
मुन आयर कोड कॉपी दे
Inter alia
कॉपी आयर कोड दे
stating that his mother has expired on 9/9/2024 and the Dasakarma is going to be be conducted on 18 and 19 September 2020. Regarding add to the reasons stated in the application, I am inclined to enlarge the petitioner on bail for a period of how much? 15 days.
15 days.
15 days? 20 days. 20 days. 20 days. The petitioner shall be released on bail for 20 days from the date of release, and he shall appear before the jail authority. He should surrender before the jail authority on or before
court ballot.
1 hour before. Jail authority or jail authority?
Release
Before trial court.
Trial court.
Before trial court. Surrender before the trial court. On or before you give the date. 20 days. Count करोगे. 20 days count करोगे. And the trial court shall release the petitioner on bail by tomorrow. Tomorrow after verification of the same verification of the verification of mother's death. What verification? He will not tell lie.
Formally no formally verification था उसे देखी दे
Mother's death, who will
Yes,
tell lie unnecessary?
without verification
Don't verify. Verification then
Miller.
one day Dasakarma he will miss. Shall be released on bail. And if you want to escape, even give the bail in any case less. Yes. Will complete and release the matter after 4 weeks. December 20. Yes. Any very urgent matter?
Small matter.
Yes.
84. Next item. There is
Yes.
only read
84
before
let
us.
us.
Yes. The minor debt director can different. I have to meet the parties, the person affected. I filed IA for that purpose. Maybe allowed.
Allowed. IA allowed. For the reason stated.
Number
90, only minor interim prayer is there.
No, let me finish it. Let me finish the order.
Yes, sir.
For the reasons stated in the application is allowed. The petition is granted permission to complete the necessary party. Filed amended memo party shall be filed within a week. Issue notice to the
First day, yes. Well, requisite by 7 days, my lord.
7
There
days.
is many.
Requisite to be filed.
7. Interim order to continue. But
Interim order to continue.
Next item, my lord.
Yes.
Next item is an application or modification of the trial court's bail order, my lord.
Which condition?
Condition at page, my lord, find at page 8.
8.
8. He said second condition, my lord. He
What?
shall appear personally before this court on each and each date of posting except grant by court. Order was passed on 5/9/2023. Ever since then, I have been appearing every day.
Then
Find that. My lord, primary concern is my wife is pregnant. I have to bear in the hospital.
and it says that except grant by the court.
That's a grant.
You moved
I have to go every day.
No, except grant by the court, it is not happily worded. It says that you can move application 205.
In any case, I have to go. I have been insisted upon to go there. That's the problem.
I don't know.
My lord, the mediation is there. ROR is the name of the person, the complainant himself. Civil court status quo is there. Anyway, those are not very.
I'll clarify that point. You can move application under 205 if necessary. If necessary. Petitioner is agreed by the condition number 2 in the secretary. He submits that although the trial court has granted the trial court has directed to appear to appear before court on each and every date. But his wife is heavily pregnant. Pregnant, therefore it is difficult for him to appear on each date appearing. In view of the condition, he will grant an application for a unit. It is made clear that as and when required, the petitioner can move an application for seeking personal counsel, notwithstanding the condition as mentioned.
So 92, the interim order to continue in fact.
92, sir.
Interim order is there.
Okay.
Item number 9.
When do you want, sir?
Any day you'll see.
Next week? And what I'm thinking is these matters which are not taken up, it will spill over to next week.
Next week, interim order to continue.
Interim order to continue. Since I'm not taking up it, obviously, there is no proceeding.
Item number 90.
There is no
Interim order to continue. My lord, item 8.
I'm not, it will spill over. Since I'm not taking up the matter, obviously, no need to.
What has actually happened, my lord, it was dismissed for non-appearance, something like that. And after that, after restoration, I have filed an application for it.
Restoration, it is restored to the original file, the interim order revives. Restored means it's restored to the original file.
Monday or Tuesday, my lord.
It will be taken up.
It's before
tomorrow.
Item 89.
Next week I will be taking up all the matters.
89 is a condition stay of.
Whatever, all the matters which are
I
there.
have filed my objection. Stay of condition.
Well, it's, may I mention item 93? Well, it's
Senior.
Sorry.
Yes.
No, in 89, my learned friend was objecting so much. He's a 84-year-old person, and without pension for the last 6 months.
Get ready to argue on the main matter.
We will, yes, I'm ready.
Get ready.
No, I'm ready to argue the main matter itself.
Get ready
and it will not take more than 5 minutes for your lordship.
It will be spill over to next week and get ready to
Yes,
argue
yes.
the main matter.
Yes.
Just don't lever on stay up for conviction.
No. We will argue on the matter.
In item 93, may I make a request for Tuesday?
Tuesday.
So grateful.
A hearing matter.
Sir.
Usually I never disturb my lord with regard to hearing. But here whether the appellant program the cancer third stage. So he wants that before my death, I should know.
I should be acquitted or I should be convicted.
Whatever it may be, whatever he is there, the cancer last stage.
Let it be there, sir. I'll take it up. Get ready.
I am ready.
Monday, Tuesday, anytime when I get the time, I'll
No, my lord, I am not ready because this matter has been entrusted to me.
from 17 to 20 have been entrusted to Mr. Niranjan Maharana. Niranjan Maharana, instead of Niranjan Maharana's difficulties, it has been entrusted to me, letter has come to me.
Yes.
I have got the file, so I will have to get ready for 3.
No, you get ready because of the peculiar condition of the.
Next week, your Lordship has already fixed 2 matters. One of Mr. Senior Advocate, Mr. Kashavangas. Next day, Mr. Senior Advocate Gautam Mishra. On 25th and 26th, your Lordship have already fixed. 27th.
There are 5 working days.
No, 5 working days. I will have to get myself ready. These 3 are.
For you, there is no problem. You can get ready.
No, need me tell you have to represent the state with So let it.
You try. Let it be there. You try.
After puja, let it come.
Let it be there. You try. Read it.
If it will all the appeals, I cannot argue in a single day. I will have to.
And you expect that all the appeals to be heard by the court in the single day. And write the judgment also. See, the appeals has to be heard. See, the problem is 2017 appeal. And he is in deathbed. At least this way or that way, at least before he dies, at least he needs a bed. That's what he says.
My lord, item number 94, my lord.
The appeal since 89.
In exceptional cases, we can very well try.
Another matter.
No, let it be there, sir.
Let
it be there whenever he is ready.
If I am ready, I will argue. Otherwise, it will be asked to after.
Yes, sir.
My lord.
Let it come on Monday.
Sorry, it will come.
My lord, 94, my lord, on 27th.
No, it will be spell over to next week. We will adjust and give it. Next week all.
ମୋର ନାହିଁ କି ତାର ସବୁ ଟାଇମ୍ ନଉଛନ୍ତି ମୋର ନାହିଁ ଓ ସେ ବହୁତ ଦୂର ପଳଉଛି ନା
You know, stay of conviction is not possible. No, I have not granted. You show me one, I'll give right now. I will. Show me one case where I have granted the stay of conviction. You go to that bench. I am not giving. Get ready for final disposal. The amount of labor you put in to convince the court for stay of the conviction. At that time, I'll dispose of the main matter. Get ready and give the number and it will be included in the list. Get ready and argue finally. Because we will spend half an hour, minimum half an hour to, to understand the case. Better you argue the matter, we will finish it up. Why unnecessary?
Well, item 86, the copy, the notice has already been sent, but it has returned as unsolved.
86?
86, my lord.
Addressee?
Absent.
Addressee absent. Although he has entered appearance.
Is not available, my lord, only for instruction. Only for direction of the expected trial, my lord, this case, and the certified copy on file.
86. While granting bail, what?
No, what is expected trial, my lord.
This honorable court, my lord, has granted the interim order in this case.
There is a, see, this was not disclosed to me.
No, my lord. This case has been filed after the order of this honorable court, my lord.
And in that court, whether this matter was disclosed.
It is his duty.
Have you disclosed that there is a...
Instruction of the petitioner and file certified copy, my lord. And the government copies for my
So is there any interim order here?
Yes, my lord.
Interim order of...
stay of further proceeding, my lord.
See, this court has, the coordinate bench, of course, it has come to me, has already stayed the trial court proceeding. You went to the other court and without disclosing, you got an order for expeditious disposal of the trial. What is this going on? You file, you bring the record tomorrow. Bring the record to whether you have disclosed to that court regarding this, the stay of the proceeding granted by the coordinate bench in this matter. Have you disclosed or not? That's the whole difficulty. What's the whole difficulty? You have not disclosed. That is the reason the court has given it.
You will not communicate with the lower court. How they will?
No, I have communicated. I have
No, you bring, you list list this matter tomorrow along with the record of 5157. Tomorrow I will check it. Otherwise, I'll impose heavy cost. I'll tell you. Heavy cost starting from 50,000 onwards. I'm not telling you, your client should have told you that there is a stay operating granted by the coordinate bench. You are going to other court and getting an order for expeditious disposal of the trial. What is this? Tomorrow, list along with that matter. Let us see. Okay. Any
Interim was there, man.
tomorrow? Tomorrow. Yes.
Again.